Good morning, my friends. Let's go, people. We've got some Karen Reads to free today. Let's get in our positivity here, folks. Let's get in our I know it's early. I'm doing this for me. If you got to do it, now's the time because I'm doing it for me. Positivity, people. Positivity, right? Need this to go well. Now, I saw and reposted an interesting tweet from Aiden. It says something interesting. It says that if I can find it, unless he deleted it. I feel like maybe he did. All right, well, maybe I was wrong. Maybe that was wrong. Hold on. Yeah, so I guess that's not a thing. So I might as well not even. Well, no, it's here. I guess I didn't repost it. That's why. Okay. Says here, posted 11 hours ago. Aiden had posted, tomorrow is going to be interesting. Karen Reed and I will be sitting together at the defendant's table in the main courtroom at 9 a.m. in front of Judge Doolin. Hank Brennan is interceding in my case for a Rule 17 motion for my phones. After that, the hearing will move into the small courtroom for motions hearing with Auntie Bev. So, yeah, so I don't know if there's going to be any Zoom. I don't know if there's going to be a phone. I don't know if there's going to be cameras in there. Hopefully there will be. So I don't know. I misunderstood. I thought maybe Aiden was going to have to sit at the defendant's table with Karen at her hearing. So it's his own hearing. But let's see real quick. Now, are they live on YouTube or? Yeah, I mean, they're live, but they're live with something else. Yeah, they're not even live. Not on YouTube anyway. Starting to get annoyed with Boston 25 too, if I'm being honest. But let's see what this says here real quick. Let's watch this real quick and then no, dude.
Just one of
Karen Reed's defense team is asking for a delay in the start of her retrial.
And that's just one of many motions attorneys will argue today in court in what was supposed to be the final trial conference before the trial is slated to start. Boston 25 News reporter Ryan Breslin is live outside Norfolk Superior Court here in Dedham. And Ryan, the defense is now eyeing late April.
Good morning to you, Ray and Catherine. Yeah, that's right. The trial was expected to start on April 1st, but now the defense, they have filed a motion asking that to be delayed until April 28th while a federal appeal continues. Now, it was last week that we heard from a federal judge who denied the defense's request of having jurors from her first trial questioned about their verdicts on the 3 charges against her. Now, they're hoping that it would show jurors unanimously found Reed not guilty of second-degree murder and leaving the scene of a fatal crash. Also saying that there was no consideration for Reed's double jeopardy interests. Now, as they appeal that, Judge Beverly Canone says moving the trial back 4 weeks would be difficult because a large amount of jurors and jury notices have already went out in anticipation of an April 1st start. In court Tuesday, the defense made other requests, including one to bar certain prosecution witnesses from sitting in the courtroom during closing arguments. And the judge ruled accident reconstruction experts, ARCA witnesses, will be allowed to return for the retrial despite an attempt by the prosecution to block them. The defense also releasing their potential witness list this week with 91 names, including Norfolk County DA Michael Morrissey, John O'Keefe Sr., and former trooper Michael Proctor, as well as his wife and his sister.
Colors though, like the bright colors to keep everyone
We are,
a little
yeah.
happy.
Now, I've got Law and Crime up. Calm down. I don't need y'all to blast and spam my chat. I can read. So I see a live feed here. This is from, but this doesn't look like the normal courtroom. It's a fan, but it doesn't look like the regular courtroom. So this could be in the room where Turtle Boy and Karen are going to be sitting together, hopefully. So we will see. But we will leave this up in the meantime. Now, is that the big room or the small room? And they are not sitting together. Okay. Wild card judge, huh? Interesting. Supposed to be the main courtroom. Right. And I've been in that courtroom for a Karen Reed pretrial hearing as well as a Turtle Boy hearing. The fan is inverted. I love it. Y'all are hilarious. And yes, Nan Gallagher will be joining Lawferio. She will be joining me very soon. She's said she was going to be cutting it like real close to 9 o'clock. So as soon as she's ready, there's no rush. If you can hear me, Nan, there's no rush. Just take your time. We'll be here. And then you just come on whenever you feel like it, whenever you're ready. All right. Now, I'm getting a lot of different information in the chat, so I'm not going to pay attention to you guys as far as information goes right now. Getting mixed signals from you guys. Yeah, Brian's always welcome. Any one of you LV cops are always welcome here anytime. Now I kept hearing, yeah, I saw that Aiden said 2 different courtrooms. Said it was going to be Doolin and then Bev. We got sound, or we had sound. Let's see what we got here. No sound yet. Only when I do impressions chasing. It's good to see you. And my Boston accent is still quite terrible. And then somebody said TV posted that Doolin is on vacation this week. Yeah, I don't know what the fuck's going on. Listen, the only thing we can do is wait. Okay, that's all we can do. The only thing we can do is just sit around and wait. Oh, while we're waiting. And here is Karen Reed's Defense Fund. It is pinned to the top of the chat now. And if you're feeling generous and you want to help her out, please donate to Karen, because as you know, she needs our help more than ever right now. I don't know what Law and Crime is doing. See, man, that's why I don't even like to stream those guys, bro. Like, and hey, while we're waiting, why don't you guys do this real quick?
Whether or not Karen Reed was inappropriately charged in the first place or charged early without having a proper investigation. So it's going to be very interesting because the state
Go give
police
these
is going to
people
have
a
to
like.
justify
They're amazing.
their investigation in the second trial. And the question's going to be, is Trooper Proctor going to testify?
Just real quick, switch over there, click on the link that I just dropped in the chat, and give Justice Served a like, because they're awesome. And I meant to send you guys over there yesterday, and I forgot, and I feel really bad. I meant to send you guys on a Glare raid over to them because they were live, and I forgot. So if you guys could give them a shout out, that would be great, and a like for their video. I would really appreciate it. So let's see real quick. I still got nothing live from Boston 25. I don't know what Law and Crime was doing. I'll try them one more time because maybe they got their shit together. I'm not going to stream Tom's stream. I don't want to take views from Tom, even though I know he's okay with it. But if anybody knows where Tom is streaming it from, I'll do that. But I'm not going to snipe Tom's stream while we're doing this. Oh, it's a Zoom? All right. Well, I guess we're fucked. All right. Well, okay. Well, then go over to Melanie's then. I don't know what to tell you. Or go over to Boston Tom's, but I'm not sniping either one of those channels. So, it's no sound. Oh, thank you for the Venmo, Drew. I appreciate it. Let me see. Okay, cool. All right, let's try this. Give me 1 second, guys. I can't copy and paste this because it's a screenshot. I have to type it in manually.
And is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. And the reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent.
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot.
Bear with me, folks.
Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
I
How
am.
is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt?
Exactly.
Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not
Look
sure
at
why
this
we're
shit
being
right
joined by
here.
Ms. Reed's team, unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're.
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of the court. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to
Yeah,
her
and why
rights.
is Brennan?
And the
This
issue
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
How does
So the case
Brennan?
number- I just
He's
wanna make
not the
sure
prosecutor.
Procedurally, I'm on the same
In Turtle
page as
Boy's
the court
case.
and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay,
That's correct.
then she needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her
Fuck
case.
yeah,
This
she
is
does.
her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it
Because she's
specifically
naked.
pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we,
which can be dealt with at a later time.
Crazy.
Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This
understand,
is
Your Honor, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue,
Dude,
even
Turtle
though it
Boy
deals
is up
with
there
Mr.
looking
Kearney's phone,
smug
who's
as
got the
fuck.
representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel,
That's all-
this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
Dude,
Did you
prepared.
give the court
This
notice
judge
of
is
that?
tough,
We
man.
did to Justice Cannoni,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court. on
Karen
various
Reed's
issues
team
Mr. Brennan
was under the
I'll take it
impression
under
this was going to
consideration.
happen under Beverly
Is there
Canoni's
an
watch.
issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my file. That's an issue in terms of the filing. So, just put it-
Gradle's like,
Thank
we're
you.
cool.
Well, Your Honor, I do object.
Of course
Ms.
you
Reed's
object.
counsel and Ms. Reed do not have standing for this motion.
Get
I
the
don't
fuck out
believe
of
they
my
should be
face.
sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object,
This
and
is
she's not a party on the
fucking
Rule
crazy.
17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion.
This judge
and
sees
her,
his slimy ass.
Thank
He
you, Your Honor.
sees your
considerations
slimy
there, too.
ass,
Appreciate you
Spanky.
accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to
Turtle Boy's wearing a
relevancy
pink tie.
and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and have identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled, because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant,
This is
much
some
less than probable cause,
bullshit.
but because of all the attendant information that we've provided. There is,
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
no, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, It's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek.
Wow.
And so,
A source
given the
told you
separate
that?
evidence that we have, and these are clearly witnesses in our case,
Why don't you just
and
say
the
Tully?
admission by Miss Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, AD Brennan. Thank you.
And so in light of the fact that this information was pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Canoni in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Carney's case, the search warrant, affidavits for the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Dude, get your shit together, Law and Crime. What the fuck, man?
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor. Counsel.
Good morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor.
Cradle.
The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. they couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this, I read the search warrant, you know, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. You know, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants.
Careful,
and say, hey,
Bradel.
don't share
You're not
this.
there to defend
hey, keep
her.
This between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney in consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, you know, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor.
Get 'em.
So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right when to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're maybe they're obnoxious, maybe we don't like them. They're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation in the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor.
This is awesome. Cradle
The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done.
I agree.
Where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communications.
Counsel, you're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there. We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
Fuck yeah.
It's going to be Attorney Elizabeth Lillard, Your Honor.
Yes. Get him, Eliza.
Thank you, Your Honor. Elizabeth Lawferio on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradle, apologies, Your Honor.
Oh, she's yeah. Don't do that. Don't do that, Ms. Whittle.
Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response.
Short and sweet. Briefly. Let's go. Let's hear your bullshit.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness in the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case. But these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That's the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids are. Yes, exactly. Right.
Get out of there. What's up, Nan?
Good morning. How are you?
Doing well. How are you? The notorious Nan Gallagher, everyone. I'm gonna turn that up a little bit now.
Oh, and you today you'll get some pop outs from my Bernedoodle, who's clearly scintillized by Hank's arguments this morning. So everyone say good morning to Roselle. She's fired up for today. So what's up? That was a bunch of bullshit laid out.
I was just gonna ask you what was your take out of all that?
Well, first I want to apologize for being late to join you, but I was listening to the whole argument, and you know, I'm assuming, I'm going to make an assumption, Will, that everyone understands the purpose of the motion, whether or not we agree with it or not. But you know, the prosecution's looking for access to already seized data and other information off of Aiden's phones, which, you know, he regularly talks about if you follow him. And I would maintain, as I have, that this would be a complete fishing expedition for the Commonwealth. In this particular case, it goes before a different judge, although it did appear to me there that Alan Jackson had made a really reasonable assumption that this was going to be argued before Judge Cannoni. In my opinion, in light of Judge Cannoni's really implicit and explicit bias recently that she's exhibited, and not just recently, but it has had an uptick lately, that it's better to go before a different judge, although I did not catch this judge's name. But with that said...
Me either.
Yeah, and I don't think it matters, but, you know, just to give a little color commentary, the judge kind of dished it to both sides, asked tough questions, the questions to the prosecution being things like, well, what is the relevance? You've got to show me the relevance. You have to show me the actual use for this data or information that you want to use at trial. And then to, not really to Ms. Little, but to Bradel, he's asking questions about the case law, trying to distinguish the case law, and, you know, putting Bradel to task to try to at least get Bradel to make any concessions that he's going to make on this issue. There was a little back and forth, as you all heard, between AJ and the judge as to the issue of, quote, standing. Just so you and your audience understand that basically means, in a nutshell, that whether... Oh, go ahead.
I'm sorry. I got the impression that the judge was annoyed with AJ and her entire team for bursting into the room and disrupting everything that was happening right there.
Did they bust in, Will? Like, I
mean, pretty much. I mean, shit was already going on, and then Karen and her team just rolled in there like a fucking gang, you know, like
like a boss.
Totally. Like full authority. They took over the entire room. And so I'm speculating that the judge probably was rubbed the wrong way for a moment there, and then got his shit together and was like, okay, let's assess what we got to do here.
Okay, yeah, because that was like where I was straddling listening on my phone and then listening in your backstage. So if they busted in, most judges would be like, who the fuck are you? If it was more of they haven't filed a pleading, which it sounds like the defense hasn't filed a pleading on this issue with this judge, the judge might make a conclusion that they have no, quote, standing to be there, which basically means a party's legal right to enter an appearance and have a say on a particular legal issue. And it doesn't look like this judge made, the judge didn't really make, he didn't make a ruling on whether or not Karen had standing, but the implication is that he allowed them to be heard. So he feels that she had a right to be there and to be heard. And ultimately, you know, the way I look at this type of motion, it is a witch hunt. It is a fishing expedition. These phones, or I'm going to use phones and data interchangeably. The issue of the communications, or specific communications between AJ and not AJ, excuse me, between Aiden and between Karen, that's already gone before grand jury. They no-billed it. It's water under the bridge. It's something that has already been resolved. And it's interesting today that Hank made kind of statements about the probable cause standard being somewhat of a high one, when really it's a really low standard, in my opinion.
It's super low because, as Bradel said, the lowest hanging fruit, the whole ham sandwich thing. Like if a
Right.
grand jury was like, there's nothing on here to indict. So
Yeah.
no, right?
Yeah.
So at that point, like if that already happened, it's on record. What does Brennan think he's going to pull off here? And or at least what ground does he think he's standing on to pull this off?
He is absolutely, there's a saying, tilting at windmills, and it is something that derives from the writings of Cervantes, which a man of Hispanic descent such as yours may appreciate that. But essentially, he's tilting at windmills. Brennan is trying to find any reason to not only do two things. One, to prove or find evidence that would support Karen's awareness or consciousness of guilt, that by communicating with Aiden and influencing him to intimidate witnesses, that she therefore knew she did not have, a viable defense to the case, that she was trying to obfuscate the issues and just try to intimidate witnesses, hide the ball, and try to save her own ass. Or Brennan is trying to say, well, this is going to give me a reason to keep Aiden away from this trial. He'll never say that in a court of law. He'll never say that in a pleading. He'll say things like, there's been evidence of a blogger, which I know Aiden doesn't like to be referred to, I'm going to say a journalist, because that's what he is. But
independent, award-winning journalist.
Exactly. So if I say blogger and Aiden's listening, I'm using Hank's language and not your own, because I do consider you an award-winning journalist. But anyway, Hank's trying to show that reasons, or to find reasons to keep Aiden out of the courtroom and away from the case whatsoever, trying to keep him from, quote, intimidating witnesses, trying to keep him, frankly, from even broadcasting, because the more he speaks, the more people are influenced in Karen Reed's favor, and they will tell two people who will tell two people will tell two people. This type of argument should not be granted. This application, it's specious. There is no relevance. Hank can't point to relevance other than to say the conclusion he wants to get at, which is consciousness of guilt, Your Honor. But the judge did ask him questions about, well, show me what you're talking about, and he couldn't. Then you tie in Liza Little's arguments, and she pointed out that there were some procedural deficiencies to the application, which also are reasons to deny it. But when you point out procedural deficiencies, that welcomes or invites the other side to correct them. So it's better, in my opinion, to follow Bradel's arguments. Bradel kind of hit the substance of them. And then also, there was this kind of tangent that Bradel was going down, which is this, even if you are going to grant this application, this data or phones have to be reviewed by a taint team to make sure there's no attorney-client communications between a husband and wife, which would not apply here, or communications between, and notice he said journalist and source, which as...
Did you notice Brennan saying source that says that there's none of that there's no attorney-client privilege information, that there's no what you just mentioned?
Yes.
Like, he said that there was a source. What that says is that somebody searched the phone. before the taint team searched
right.
it. So Brennan just basically just put something on the record that Bradle and Betterow can use in Turtle Boy's case.
Yeah, I was shaking my
unless
head.
I'm wrong.
You're right. And who in this I'm going to say room, but who on this channel and this stream right now thinks that Brennan hasn't even that he has not reviewed this already? He's reviewed it. He's colluding with Cosgrove. They're, you know, because of all the reasons that have been discussed on a bunch of different channels recently, you know, they kind of ambushed Aiden with respect to his hearing. Was it 2 days ago? Yeah, I've lost track of days, but they are colluding. They're making applications to, you know, stick it to him. And it's all really done to achieve those two things. They want to stifle Aiden and keep him away from the trial. And they want to try to find something that shows Karen's consciousness of guilt. I can tell you all, if this motion was before Cannoni, she would grant it because she's granting all of those other motions that have been filed to procure notes of journalists' notes. So I'm happy it's before this unknown judge to me, but I can't get a read on him. Cannot.
He seems fair so far. He just seems like okay, like he sat down at the bench and was like, I'm not for the bullshit today. I just want to know the facts. Let's go. And I'm cool with that. I wish Bev was more like that, you know?
Oh, me too.
But I have a question for you though. Now, do you think that what happens here will be whether or not Brennan calls Turtle Boy to the stand or not? Will this be what that depends on? If he's able to get the phones. Will this affect whether or not Brennan decides to call Aiden to the stand? If so, how?
I don't think it will affect whether he will call him to the stand because I don't think that Brennan has, as apparently everyone in Massachusetts says, the minerals to do it. I say the cojones, but Brennan doesn't have the minerals.
I say the ingredients, or I say the stuff.
Yeah, the stuff. Okay, so I've got a bunch of synonyms now. Brennan does not have the stuff to call Aiden to the stand. He just doesn't. And Aiden,
I don't think so either.
Aiden has made it very clear, no matter what guardrails are put into place, like he's going to speak.
Yeah, let's also not overlook that Aiden was staring at Hank the entire time the camera, at least every time the camera got on Aiden, you could see him staring at Hank and smiling, basically smirking. So
the law and
Aiden's already playing chess with this motherfucker. Like he's already playing chess with him.
And the law and rules of evidence are on Aiden's side on this. And they're also on Karen's side on this issue. It's on their side. And I'm saying that about them separately because they're really actually two separate individuals as it relates to this application. And the judge was kind of right when he's like, hey, why are you here? Does she have standing? Because her matter is a separate criminal action. It's Aiden's phones. They already have Karen's phone, phone or phones from prior, whatever time they were seized in the past. So Aiden has privacy rights here. I just don't think that Brennan, the outcome of this motion will affect Brennan calling Aiden to the stand. He's not going to do it. It's too much of a powder keg of, that coffee looks delicious, by the way. I'm drinking a double shot.
Oh, yeah. I actually, when the hearing starts, I'm going to bust out some glazed donuts and y'all can kiss my ass. Listen,
Yum.
Paul O'Keefe, you're not ruining glazed donuts for me, okay? They're delicious. You sick fuck.
They are good.
They're too good.
Yeah. Oh my God. I'm like looking at your chat. But guys, I am only maybe 1/4 caffeinated right now. So you're going to see some stumbling this morning. But I think this is a big derailment from more important matters that have to take place. And I'm not really trying to say that what Aiden's going through isn't important, because he doesn't need this bullshit either. But as
No.
far as, when we look at a current trial date of April 1st in Karen's case, which might get moved based on the joint application that was filed to push it till the latter part of April, with an April 1st trial date and with very significant in limine motions that have to be argued, and with the now new issue, which I haven't looked at Twitter much today, but I don't know if there's been any additional filings, but this new issue of Proctor's termination, that is going to also become an issue in the Karen Reed case and will likely be the subject of yet another late filed, and it would be no fault of anyone because it's late filed, but a late filed in limine motion, because the Commonwealth isn't going to want any evidence of his misconduct, that meaning Proctor's misconduct, coming before this jury. And you might see a similar motion from the defense.
I'm sorry. Hold that thought.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Giannetti.
Good morning, Mr. Netti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with, it's paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
Come on, Bev.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance, and I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different, but most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have juries coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st.
Oh, God.
It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st.
Hell bent on April 1st. Hell bent on it.
All right,
She needs
so
to
let's
get laid.
go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have. I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
I volunteer Scott McGinnis.
Okay. All right. So I'll hear the Commonwealth.
Me too.
Lay down that game, Scott. Lay down that game for anti-Bev, buddy.
I'm telling you, a jury's not
One of
going to
the
like Brennan.
Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned, based on past reports and information, that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but
shut up.
Influences
that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence in the jury, I think, can affect the sanctity of the jury. I don't think.
How about
it is a strong
fanning?
Position to consider the
Right.
streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
He's got no proof of that.
Right. There's a portion of your motion that I
Wanka.
disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. So I don't
Wow.
think that burden should be imposed upon the court.
I think they've squandered that duty.
All right, with that, does the defense object to the buffer zone?
We take our position.
Okay.
What?
All right, I'll take this under
They-
advisement.
Yeah,
I have
they,
to
they did the same thing
figure
last
out
time.
exactly how far this is, and I have not yet had a chance to read and consider today's email from the merchants. Okay.
But it's like, why expand the buffer zone that she set last time? You know what I mean? Like, she's the one who set the last one.
From the record, that came
I
from
agree.
Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Oh, must be a farmer's market in Dedham.
So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So
Why do you need
and
cities and
there's a lot of
towns?
overlap, and you'll have to fix that for any final trial conference report anyways.
Oh my God.
All right.
To make sure to measure how much of a chance of them being influenced by this case, I would imagine.
Your Honor, can I be heard on that one issue? Just briefly.
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll
Okay.
happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Who the fuck puts a footnote on a witness?
I was thinking that same thing, but I didn't want to say nothing because I didn't know if it was standard or not. But it sounded weird to me.
Yeah, your audience is going to get some
Your Honor, the motion notes that the Commonwealth
comments
moves to
from
be
me.
partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of
Oh my
witnesses,
God.
which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal.
Oh my God.
I think that
Turtle
is
Boy's tweeting.
protecting the interest of the Commonwealth and
Watch.
the witnesses from,
I don't have a problem with that. I still need cities and towns.
of course.
Okay.
Yes.
Take you 10 minutes,
Wow.
Brennan. 10 minutes. You can get that done.
Thank you. So
Just-
we will
just sit down,
start
dude.
with
Put Lally to work.
Just
paper 593. The
Lally's
Commonwealth's
already at work,
response
fucking-
is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
What-
Lack of bias.
Yeah. By the way, anyone in the chat, did you hear what
I'll go
number
first, Your Honor.
meeting that was?
Oh, it's defendant's motion. The
I'll be right
Commonwealth
back.
Opposed it.
Anybody help a
I'm
girl
gonna
out?
ask Who's arguing that for the Commonwealth? That's why
I'm
I-
sorry,
I-
defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever. the
I'm
court
fine
prefers.
with them going first if you'd like.
Okay.
Thank you, Kimberly Johnson. Ooh, sorry about that.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment, at the time they wrote the report.
That's because they
and
were.
then
Heard.
subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report.
Correct.
I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties.
Doesn't matter.
Witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we
That's an
know is that
overstatement.
the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given.
They listed
And
them
so
in their
clearly
report.
There is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory.
You can
And
ask
so
them
that's
on
why we began
cross-examination.
by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective.
But they were.
Just to give one point that emphasizes the concern. The ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA and
Swabbed from where?
Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information. And then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received.
Wow.
They should answer questions about
Fishing
what they were told
expedition.
or what they knew about the case.
That should never, ever be allowed.
All of their correspondence
Of course
with the
not.
defense, including phone calls, emails,
He should have been he should have been a proctologist.
It's not a Lanigan hearing where I question their qualifications.
It's Morrissey still just trying to fish and find out what the feds were investigating.
They truly should be objective.
Yep.
And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should.
Dude, you are so obvious.
We do not have the opportunity to question the United States Attorney's Office. We resigned to TUI letters, which inevitably have been unhelpful. So I think.
But I thought they closed the investigation and you were celebrating it.
To have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence.
Jesus, Hank.
The role
Come
of
on,
the
buddy.
federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which
Don't be so sure about
quite
that.
the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Bring it, Yannetti. Come on. Take a deep breath. Let's go.
One of the,
He's got it. He's got it.
Commonwealth and the defense
The
certainly have
cerebral
opposite
ninja.
arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth.
That's it.
In the first trial,
Simple.
this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved.
Right.
That didn't end well.
We'll agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all,
I can answer that
later in my argument. We're not asking.
So no, could you answer that now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you just
if
said
I
it's
can-
late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but
Chill
I'll
out.
address it now.
Okay.
Chill out. Come on. You're the cool one, Yannetti. You're the cool one. Keep it
We are
cool.
not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office
We're the ones who
these
hired them.
witnesses. That's it.
That's it.
We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered. Nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client.
I
Love
love that he's
they
arguing
were
this.
potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government. And I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA
It's a great argument. Great argument.
Federal government
Yeah,
to prevent
Yannetti's amazing.
speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired
like taillight pieces.
We read that.
It's revealed
information
themselves.
at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court.
That is what you said.
To issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes.
Oh, Jesus Christ. He's like a wart that won't go away.
I know. This guy fucking sucks.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth.
Okay.
Or a slice of it, not the advocate side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government,
excuse me,
the jury is entitled to hear the
Man.
whole truth, then they should know the motivations behind the hiring, the input
Knock
from
it
the
off.
defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew.
It's new to everyone watching. I hope you're
I
listening.
don't know how the defense
Dumbass.
knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was
What are you
obviously
suggesting?
a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading.
What?
Suggesting no relationship with the defense, talking about DNA with no DNA evidence.
That's
I do not think
he's
that
teetering on an
witness
ethical
should consider the
violation.
witness a trustworthy guide unless
Well,
they
he's
establish their
he's
credibility. I
putting
don't
all
think
his
that's
chips in on Bev being
So I will
pissed
need
off about
materials to hold them in check and to
the
hold them
payment.
accountable for
Yes,
whatever it is,
yes, that's a
is
good
their
point.
bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in.
Bullshit.
Tell the whole truth. It has to be the whole truth. And I think that
Unreal,
becomes a
man.
dangerous game. There'll be an entire entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right.
Of course, they're going to call the ARCA witnesses.
Got to have a voir
We're gonna
dire
move
next
on. I'll
week.
take this under
Okay.
advisement.
Can I just ask the parameters of that? voir dire,
Right,
the purpose of
exactly.
that voir dire?
Bullshit.
What the fuck?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on and I'll hear any objections.
What kind of shit are you trying to pull, Bev?
But she won't make a ruling on having an evidentiary hearing on
Right.
extraordinary prosecutorial misconduct
All right,
or
so next motion is the defendant's motion for stating grounds
You
for
dirty, dirty,
objections.
dirty
I
cunt.
hear you on that, Mr. Yannetti.
this
Twat. Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in, one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that, we have a jury sitting for weeks at a time away from their families, away from their jobs, and any, sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection. And I had no idea what the court's basis for the ruling was. We would go
Neither
to
do I.
sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
Oh shit.
Oh, I understand, but
Dude,
it's
Yannetti is
what's the
woo.
basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You
I'm-
should have known the basis.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the
He's
jury.
right.
My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity.
He's also right on that.
So, we think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied.
Oh,
So the next motion, defendant's motion
Guys.
eliminate to exclude false and irrelevant
awful.
statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay,
So we can agree to that motion.
all right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal.
No voir dire for
Before the
Crosby?
witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the
didn't
Commonwealth's
hear it
going to
well.
call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So
Oh, I
we
love
don't
this.
need to belabor this. We talked about this before.
I love this.
No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So
Okay.
there's that.
Improper for
That
her to
doesn't-
say that.
But that
So
doesn't.
I think now
it
we'll
doesn't
move
solve the
on to
problem.
something that may take a little bit more time.
Can you guarantee that
The
one won't
defendant's
be in
motion
charge
eliminated
of
to
the jurors?
exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan?
Judd the Chud.
Welcher, and the Commonwealth's opposition. So who's arguing for the defendant, and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Lisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick.
Just grant the Commonwealth motions. You're going to do it
I
anyway.
just wanted to know if the defense
Right.
had objections to.
Just for your audience, I missed the
To appoint a
motion.
stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
I missed the motion
Thank you. Which motion, Your
before.
Honor?
It's your number one, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
I don't know why that has to be argued. That should be granted. I missed the motion before prohibiting contact with jurors.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media,
This is
jurors,
all about
although
Turtle
maybe
Boy.
not identified by name,
Yep.
have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want.
How about you don't have
So
Brian
jurors,
Albert
I suggest,
stare
should
at
not
them?
be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the
Aiden's
process
shaking his
of
head.
deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Yeah, but Fanning will still commandeer
Objection from the
them.
defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The
right.
motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion perhaps incorrectly that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to
All right,
address.
so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This
change.
is a new trial, Judge.
Right,
I've
no,
been
so
told.
just to be clear, this is a
Yep.
change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to
The new
prevent
trial, Bev.
jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time
Yeah.
they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
The interest of justice, Your Honor.
I mean, yeah, but it's up to Brennan to argue it.
Yeah.
I don't have an answer to that.
Of course you
I'll
don't,
look into
stupid.
Because it is a
Flipperhead, clip
concern for the
that.
Commonwealth, but there needs to be authority, and I can't say right now I have authority for it. I can
Wow,
tell you
it's
the
the
concern is that
First honest thing he said.
many of the sidebars
Follow with a lie.
vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the
Stifle?
community
Except it
of the
is.
full value of
What
the
is a
public trial.
stifle?
Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which
Holla!
I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not. But I can't tell you that now.
All
Give me a
right, so
day or
I am
two to come up
taking
with
a
some
lot of these
bullshit.
motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
To find
Exactly.
authority,
Yeah, to come up with some bullshit reason, right?
sweat it out, Hank. You
Is
ain't
there
going to
an
find any.
objection to
Stifle it, Spanky.
577? It's the Commonwealth's Exhibit 3, Motion 3. Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, two photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate.
Very important motion, guys.
You on that? Yes.
Very, very important motion. Hank wants to hide the truth here.
Pursuant to Mass case law, Como versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death. But this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different from questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
Manner of death, you idiot.
Defense, Ms. Little.
Thank you, Your Honor.
Is this 578 or 579?
In this
578.
case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court
That
looks
is
closely at
clear-cut
the cases
exculpatory
cited by the
evidence.
Commonwealth, specifically
Peter Silva,
Commonwealth
the
versus
ME is on the defense list.
I'd urge the court to carefully read that opinion because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law.
Dicta
The better
is
and safer course
extra
exclude from a death
writings in a
certificate the
case,
words
a court opinion.
homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I
For the
believe medical
Commonwealth.
examiner is not on their witness list.
Oh, I thought I saw her. Dr.
Yeah, on the
Scordi
defense
Bello?
list.
On the defense's list. Yeah, she's on the defense list.
Not on
Dr.
their
Scordi
witness
Bello is on the defense list.
I would have
Yeah.
wanted to hear.
How do you
Yeah.
how do you not call the medical examiner up in a murder trial?
It's a
How does the
mortal.
process-
It's a mortal wound. They've tried to
One on the Commonwealth's witness list.
call another one with who didn't examine the body. They want to call that neurosurgeon who's not
I'll
a
take this under
forensic
advisement. I'll take a
pathologist.
quick look at Ellis again.
Take it under advisement.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay.
Wait a second. That's supposed to be the motion to
One more.
to subpoena
So
my
that's
notes
Paper 580, Jim?
from Karen Reed's appearance on my fundraiser stream.
Commonwealth's
That's
motion
579.
eliminated with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Your Honor?
Sure.
Bring it. I would have liked to have
One of
heard
potential
Brennan.
Jurors are asked
No,
when
forget
they
it.
fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely.
Oh shit, my bad. Sorry.
We're professionals here.
If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other
He's
words,
right.
it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
He had to ask him what the practice of the office was?
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It actually seems to be both.
Both.
I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense.
Bullshit.
I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact,
Oh my God.
What?
In re-entered society, who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. It, I understand, may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, you know, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving the
thought-
jurors a chance to correct what they put on the initial form, there's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
All right. So that's usually about 15 minutes. So man, spicy Yannetti today, huh?
I'm very happy to see that. He's hit,
Me too. It's not something I've ever seen before.
I think he's hit a point of like, I'm fucking fed up. You know,
Yeah.
he's always been a little trepidatious because that's his jurisdiction. He's got to practice there. He goes before that judge and others. But, you know, as Turtle Boy calls it, the hackorama. And, you know, how many rulings are going to come down where lawyers who've been practicing even far longer than I have are saying, why am I trying to even follow all the rules when ultimately I'm going to just get denials of reasonable expected motions that I'm filing, and things filed by the Commonwealth just get rubber stamped. So he's spicy and I'm here for it. Like, I think someone should invent a drink called like the spicy Yannetti. I would drink that. And I drank it up today. So
Yeah, I did too. Let me read real quick a tweet from about just under an hour ago from our friend the mighty Mark Betterow. He says, I've never been more disappointed to watch a court appearance from afar rather than attend and argue in person. Great job by Tim Bradel defending against a clear abuse of the government's subpoena power against Dr. Turtleboy and a desperate attempt to establish another's alleged consciousness of guilt. Beautifully put.
Oh yeah. He's I have to say I don't know if he would agree with me, but I find Mark to be, even in his with guardrails right now because of his prior involvement or relationship with or anticipated one with the Reed team, he is coming down with some soothsaying. He's really targeted with pearls of wisdom that are not only spot on from a legal standpoint, but also very inspirational to the Free Karen Reed movement. And you all need that, you know, you all need that. So if you're not following Betterow Law on Twitter, you should. And
Yeah.
And if you're not on Twitter or X, you should be, and just follow Betterow Law because he's spot on. You might want to follow Lawferio.
Well, yeah, and also, you know, that's Twitter X has been the number one, I'd say, engine of spreading information on this case. So I would absolutely encourage anyone to just start a Twitter account. It's very easy, it's very quick. And share this hashtag Karen Reed, hashtag free Karen Reed. And really put that information out there, really help perpetuate it. Yeah, so going back to Yannetti, his arguments were just amazing. I love that he really drove home and really emphasized this time about how Karen Reed has the right, because I've been singing that song for a year, you know, how Karen Reed has the right for the jury to know the truth, the jury to know why ARCA was even there to testify in the first place, that they were not independent, that they were not hired by the defense. And Brennan is just trying to get through this with a lie.
Yeah, but you're 100% right. But also, Brennan made some sound bites today where he's like, this should be about being transparent and getting to the truth. Those words are going to come back and bite him and the Commonwealth in the ass when that day comes, because all the Commonwealth has done, and law enforcement currently and before the trial started, is hide and subvert the truth. So
Agreed.
Yannetti is shedding light, and he's, somewhat sometimes an unsung hero in all of this. So he's hit that level of, I don't really fucking care anymore, but I'll be as ethical as possible. But I have told judges, you're interrupting me, and I really don't like that. She never does that to Brennan. Never. She's done it to Alessi. She's done it to Yannetti. And frankly, I think she's done it to AJ as well. Like they're somehow causing a play.
She never cuts off Brennan. She never argues with Brennan ever, ever, ever. And it's interesting because this, I think that I totally agree with everything that you just said. It's that Yannetti is at, you know what? I'm over this shit already, but it's also, I think this was also something that Karen Reed and her team predicted. They don't expect Bev to grant this motion. They don't expect her to do so at all. But what's interesting though is for us, the takeaway to take out of this, put it in the file, put it on the pile of stuff that they're just putting on the record. When they know that when they know that Judge Beverly Cannoni is going to deny a motion, they will argue the motion driven with the purpose of it's going on record. So when we appeal, all of this stuff is happening. And I think that's what David Yannetti that's what was fueling his argument there, was just making sure that everything he said was on the record. He didn't think he was going to make a dent with Beverly Cannoni on that.
And that's one of the most important motions that, in my opinion, has been argued thus far, including today and the other day, because I'm hearing an echo. That might be my fault. But I have been saying, that issue should be cleared up for the jury because there was confusion, and there are evidence rules that are designed to prevent not only prejudice, but misleading or confusing a jury. So I was very happy to see that this motion had been filed, and it's a reasonable argument, and the judge can put into play. Like, she doesn't have to say, okay, I'm going to let the jury hear everything. She can say that they were hired by the Department of Justice, and then she can put in, essentially it's called curative instructions. She can say, or stipulations. She can say to a jury, you are not to read anything into the fact that these experts were procured.
Right. There's all kinds of ways that she could do this.
Yes.
So and yeah, that's what David Yannetti was doing, was presenting her with these options. There's no reason, Your Honor. We're not talking about pushing and shoving down the throat of the jury that there was a federal investigation and that DA Morrissey was under investigation. We're not planning on even touching that. But the jury has a right to know the basis because they were misled last time. So they have a right to know the basis. If we're in pursuit of the truth and in pursuit of justice, the jury has a right to know the truth.
Right. And again, you get gaslit because you have people like Brennan who says, yes, it's all about telling them everything, bringing the truth to them. Well, sure doesn't sound like it, because everything else coming out of his mouth is to hide the truth or to bark up the wrong trees or to try to make something look bad when it wasn't. In, for example, the quote relationship between Aiden and Karen, which is specious at best, but they had every right to communicate with one another as journalist and source, and or he was digging into this case, as we all have, and maybe me from a different perspective because I'm and you will, because we're not from the area. But it's an interesting case. That's what brought my attention to it back in 2022 and 2023. there was also, some of these motions, if your audience wants to know, like they're normally filed, there's no challenge to them. They don't have a big impact on the trial itself. But the big one that was very important is number 578. 578 was the one concerning the Commonwealth trying to redact or remove any reference to the manner of death from the death certificate. If that doesn't make all of you and you there, Will, in Tennessee, go, what the ever-loving fuck is
Right.
going on here, then I can't help anyone here. First of all, just for color commentary, I think that was Eliza Little's best oral argument on any issue that I have ever seen. It is a pivotal issue. The jury needs to hear the manner of death. It was undetermined. Scorty Bello wouldn't bend, no matter how much the now Mr. Proctor called her a whack job. So the jury gets to hear that. There's case law that supports it.
I completely agree. And I think that Bev is literally the only judge that I would ever imagine would even consider leaving that out.
Right. And
I mean, that is crazy. What, like, I every other judge I can imagine, even including the judge that was sitting up there hearing the Turtle Boy argument, right?
Right.
I could imagine any judge seeking the truth to go, okay, wait a second. I need you to explain to me why this case is so special that the medical examiner's determination should be redacted from from the evidence. That makes no sense.
And a good way to think of it in your mind,
You better convince me.
and in everyone's minds, think of it this way. The finding of undetermined as the manner of death is equal to homicide. It's equal to, accident, whatever I think it's 5 or 6 manners of death that are set forth by statute. So whatever they are, the one that's popping into my mind is homicide, which is actually not murder. It's death at the hands of another. There can be homicide without intent to commit murder. But the point is, undetermined is equivalent in levels of importance for a jury to hear as homicide is. So you and I, when I think of it that way, I know right now, what if it was the cause of death was murder or homicide, excuse me. It was homicide. And the defense was trying to make a motion to redact that. Like, Your Honor, we don't want the jury to hear that homicide is the manner
The
of
judge would laugh at that. The judge would be like,
Correct.
what?
Correct. So
You don't want, but that alone is absurd. So how absurd is it that the prosecution is trying to get this kept from the jury? That is insane.
Yeah, it is. And this is where, I never even try to criticize the
Go ahead, I'm listening. I just got to
walk away. I never try to criticize the defense at all, but I wish I would have heard that little piece of an argument. I wish I would have heard Ms. Little, who had an excellent argument on this, very confident. I'm happy to hear her chops today, but I wish I would have heard her say what I had just said, which is, what if we were asking to redact homicide from this death certificate? The judge would have laughed her right out of the courtroom. While Will is doing whatever it is he does, there's a couple of other motions I'm happy to point out to you guys, which I thought were somewhat notable to me. In terms of the very reasonable motion that Yannetti argued to just have objections stated on the record. I know we've
wait 1 second, because I did promise, and we only have 15 minutes. So I want to give the audience a chance to I want to address their questions first, real quick.
Yeah, anytime, guys.
So Danielle Franz asks, what if they can't find an impartial jury? Will it be a change of venue? There's only a couple here, by the way, so we should be good. Will there be a change of venue? Is there anyone above Auntie Bev and Morrissey to investigate them?
Okay, before I answer that, I just want everyone to know, like, at this point, and if Will ever has me help him during hearings or the trial, moving forward, that maybe Will, like, if
I'll
people
think about it.
yeah, you think about it. If people like do super chat, if you throw it up, because you were listening to these hearings, if you throw it up on the screen, I'm happy to type an answer to that person in your chat because it will then come to my attention. So Danielle, if they can't find an impartial jury, I'd be surprised. They have to. It's okay to know about the case. I'd be shocked if
Right.
people don't know about it. It's the issue of being impartial. And yeah, could there be a change of venue? Yes. Or could they keep the venue but ship in jurors from another jurisdiction? They can do that as well. In fact, I want to say I heard Jason Boyles talking about that on last night's Brit Happens, which I was listening to this morning, about people being shipped in from another county. That wasn't a great fix.
I have a question in regards to the change of venue. If there is a change of venue, would that mean that there would be a different judge?
Not necessarily.
Okay.
I don't know all the geographics up there, but I learned yesterday that Stoughton District Court is right like 7 or 8 miles away, or 7 or 8 minutes. I don't recall, but very common if it's not too far for the judge to be the same. So do you want to read these, Will, or do you want me to read them?
So Lawferio in the glare, is there not anyone that someone of all of us can contact and make complaints on this bullshit from Beverly? How is this real? Not until after trial, I don't think. I think this is a question that gets asked all the time, as well as Danielle's question, the last question on her super chat, which was, is there anyone above Auntie Bev and Morrissey to investigate them? Well, that would be the feds, but apparently the federal investigation's over.
Or so the prior,
or maybe this would be a separate federal investigation, and maybe a new one would open up. That's possible.
Yeah, and I'm not convinced that this one closed, but you're right. A new one can open up, but I think it's still open. Also, I'm a little limited as an officer of the court to give guidance as to how to pursue filing complaints against lawyers and jurists. But I can tell you this: if you Google it, you will find the answer. And I think what Will said is correct. After the trial is the best time, because
that's
honestly,
what I've heard. I don't know.
It might also be moot. If Karen's acquitted, I don't know how you all feel up there or take your temperature in this chat, but you all may just say, great, okay, it's behind us. Or you may say this was a fucking complete waste of time and we want heads to roll.
How would it still be moot even though Karen beat the odds? You know what I mean? Like she still had to fight a corrupt system.
Yeah,
even though she won doesn't mean that she didn't fight a corrupt system. Does that make sense?
I hear you. I agree. And I don't think it would be moot. But I know how some people think, which is they need to mentally put this baggage behind them. Others say, I want heads to roll. I want, consequences.
Yeah.
So it really, it's up to people. But the answers to that in terms of someone you can contact, it's readily available online if you were to look that up. And I will say this, if I were a citizen up there, I would be strongly considering that option. But I would also mention that just as someone who supports Turtle Boy, he kind of, I don't want to put words in his mouth, but he says that that's the wrong tree to bark up right now. But that's his opinion, and your opinion, fun size, might be different than his.
Yeah, like if your question boils down to what can we do about this right now, nothing. Like, hence my desperation in tagging Donald Trump in a tweet. You know what I mean? Like, that's I don't expect him to do anything, but it's like at least I did it, just to see. You know what I mean? Like, who knows?
I agree. And it's some of these, everyone feels these things differently. So I think it's worth a shot. But I know you're popping up more super chats, which I'm happy to answer. And also, can you?
I don't think I am actually.
Okay,
No,
guys.
That's it.
So
it's okay.
Just so you know, if there is a question you you want me to lay eyes on while this is streaming, or it has to be?
Yeah, well, I mean, no, I mean, you do how you want. I want to be able to address the questions if they come in. I mean, people are super chatting to have questions answered, so I want to be able to. I just don't want to miss them.
And Will, if you even if you pull regular comments, if you get them on the screen and leave them linger there long enough, I'm gonna do my best to try to type
Okay.
answers, which I do
Yeah.
through my phone because I've never connected my I'm not connected to the super chat on the computer. But also, if you all notice, she summarily denied any request to move a consented to movement of the trial date to later in the month because she's already summoned all of these jurors. That's
She
ridiculous.
flat out denied it. Like she was ready to deny it.
Yeah. And she's like, well, we won't swear them in yet, and therefore jeopardy won't attach. That is absolute bullshit. They asked for
Right.
like a 3-week postponement. Come on, guys.
There is some reason it could be nefarious, or it could be something as simple as she's got cruise tickets and
Yeah.
she wants to make her cruise. Who the fuck knows? But she is hell bent on that shit starting on April 1st.
And the way it works in real life, guys, like maybe she's got cruise tickets for that particular day, whether it was like the 25th or 28th of April. Very common for lawyers to ask for an adjournment with the consent of your adversary. And even if this proposed date, which the court makes you propose, is not available for the court will work with you and say, well, I'm not available in late April, but how about May 11th? Or how about May 15th?
Always.
It
Yeah.
just happens
There's
all the time.
always continuances, dude. Like always.
Right.
Well, I mean, that's not technically a continuance, but it's just a postponement of the date. Like, okay, we want to make sure everyone is properly prepared so that the defendant gets a fair trial and so that everyone has a fair chance to have their strongest argument. Like that's, within reason, you work with both sides as a
Right.
judge.
And the fact that Brennan and the defense are like both consenting to it right now, that should tell you something because they don't like each other at all. I know time is
I like this question actually a lot. Thank you, Mandy.
Oh, thank you, Mandy. I think she denied the motion for speaking objections because she wants to decide in her mind how she would couch the objection. It gives her blanket discretion for her to say, oh, you know what? Okay, sustained. What stunned me are a few things. One, it's very, very common in court for there to be just a simple 1 or 2 word objection raised, like objection hearsay, objection relevance, objection asked and answered, whatever it is.
Yeah.
But what really stunned me about the argument was that Yannetti was like, we had to keep going up to sidebar, which I dare say was actually not that much during the trial. There were many times where I'm like, oh my God, ask for a sidebar. And I get it. You don't want to upset the jury. What really bothered me was that when today he's like, there were times where I said, Judge, can we have a sidebar? We'd get up to the bench or wherever that sidebar is. And the judge would say, what is the basis for your objection? Like if she's going to prevent them from stating the basis for their objection in 1 or 2 words, then why is she asking that question when they get to sidebar? So all it does is further prove my theory as well as many other people's theories that all she's doing is supporting and trying to bolster the Commonwealth. Like, and at the time it was Lally. Lally didn't know his ass from his elbow. So Lally's like, objection. Anytime he didn't want a question asked and answered. And the judge almost 100% of the time sustained those objections. And she even went as far as asking him on some occasions if he was going to object. So when she does it this way, it's unfair. It does deprive really both sides of this robust opportunity to preserve a record. And the attorneys, most notably the defense, they cannot get up to the sidebar every single time. The jury is going to fucking hate them. So anyway, there's your answer, Mandy.
Excellent answer. Thank you for that. Because that's
By the
it-
way, oh,
it's you present Bev with a motion that tells her how to do her job, she's gonna fight you immediately. Like on principle, she's gonna fight you. Like we know her well enough by now.
we know her well enough by now, and it's not in. This is not the way we do it in Massachusetts. This is not the way we do it in this court. She even went as far today. And by the way, throw up the hearing. I don't have access to all you see, but if you see that it's back on, feel free to shut me down. But we even saw her today.
I have it here. It's not. It's just the fan. See.
Oh, see, only fan, only nan. But we saw her today.
Oh, we're back actually.
So, Will, I'm going to be listening for the next like 5 minutes, but I'm going to be off the screen. But I am here.
Gotcha. There's no sound yet. I don't have it muted. There's just no sound
Before
yet. There we
we
go.
begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify.
Wow.
And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements.
Of course not, because we didn't think you would fucking.
On what issue is before the court that would justify a voir dire. I just want to make sure. I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay.
So it's
That's
basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them.
Dude.
They're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay?
Why?
Well,
Why
in
do you
advance.
need that?
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications
Here we go.
parties, which is necessary to understand. So it's not simply Rule 14.
Dirty motherfucker.
We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right. So talk to Mr. Alessi in advance. All right. And I'd like
He
you to
wants
be able to
details
tell
on the
me
Fed
before we start the
investigation.
trial where you stand with that. Okay.
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right. Thank you very much.
Nobody's
All right, so now
pleased
we'll
to
go on
speak
to
with
your
Brennan.
motion, Mr. Alessi.
All right. Hey, Will, I'm listening and I'll be back.
Gotcha. What's he doing?
May it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that? Or
Oh,
you
come
just
on,
outlining it?
man.
I do not, Your Honor.
Bev,
Thank
you
you. Go ahead.
suck. What an
In my
asshole.
presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation.
Okay.
What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties
Baby
have
boy.
cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the apt Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf, and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said, and it's not my pejorative, that's the ipsi dixit comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area. In the Dalbert Lanigan analysis, it's referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the decedent. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion, "her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintalo. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintalo was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintalo. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Gianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Gianelli's methodology or experience. Instead, it appears that Gianelli designed these experiments on his own without any guidance. Reading down below, quote, Gianelli's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Gianelli did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. Continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And We've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanettes 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading.
What?
Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is
Talking about Jen McCabe's testimony?
stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1:1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground.
Wow.
So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., etc. And of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to
My
introduce
coffee
that
machine.
evidence,
That's
Mr.
what it is. My coffee's welching ass. That's the sound of my coffee maker welching ass.
He would not be offering a cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one.
Sure.
Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure your honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper.
Right.
So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect.
So you want him to testify on taillights and whether or not they get cold?
But frozen ground, we agree that would not come in from Dr. Welch.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary.
Right. Extraordinary. Amazing that he knows that.
Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area. but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that? What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34.
Yeah, like who the fuck is this guy?
More egregious than H.
He's got the whole
Romanet
case
I.
figured out.
So with regard to Dr. Welcher,
Ass Welcher.
I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds, based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment.
Ass Welcher.
And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rentola talks about. The eye gets, both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas.
Ass Welcher.
In conclusion, Dr. Welcher is not qualified
Ass
to
Welcher.
do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis
Right.
for an opinion.
Exactly.
You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely
A bunch of
references
bullshit.
it doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly.
Your Honor, it's just an ass welching. We need to redact it because there's a lot of ass welching going on.
Similar to Arca's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be. It's not proper, and we wouldn't try to.
Do you intend to use all 140 or however many?
No, that is, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm. And also, we would want to show the ways
You guys are killing me.
based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that.
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled
Look at
to
Nathan.
know.
Right. So this will have to be provided to you prior to it's done.
Thank you.
This has
And
got to
then
be the
we have
most
dates so we
ridiculous
can
motion.
adequately prepare for trial, Your Honor, in cross-examination.
When will you
Agreed.
have the redacted slides?
Like, this witness is ridiculous that they're trying to admit.
Okay.
And Your Honor, if we have an issue, still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to give the basis.
Sure. So you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond, and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries.
So
And
gross.
even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
Dude, like Brennan is just throwing mud at the wall and hoping it sticks with all these insane motions. Like,
It was a
I can't
really
believe he's
good
trying to admit that witness and have that
I'm
witness.
particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush.
Wow. It's violent.
I'm not going to digress the way he has, but
Oh, he's going to regress.
and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave
That's the only similarity.
Information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at.
He's just making shit up.
What any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly,
Then why the fuck is it on there?
One regarding Julie McCabe and grand jury minutes. He won't reference grand jury minutes in the abstract, let alone the details of it.
Dazzo.
Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground.
He has to go potty.
Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher.
Ass Welch.
So the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw it,
Wow.
but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a
No, he
specific
said it was
study.
awesome.
That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet,
Their
not only were
Daubert
they allowed to
hearing
offer this
set it
evidence,
forth.
it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they're given. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the tech stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The tech stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. we know based on the phone data, Mr. O'Keefe's phone data, when he was in the car until we have all that evidence. And as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does.
No, he doesn't.
He
has nothing to do with Apple Health data.
At Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible.
That's
And we
forensic
see
data.
the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see
That's
through his
bullshit.
demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent
Look at Aiden.
witnesses.
I know
He's tweeting the fuck out of this right now. He's like, this motherfucker right here. Dude.
I was going to say that.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the
He
court
must have just
disagrees with
posted
as to
something.
those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm.
Get the fuck
That
out
is
of my
based on
face with that.
Engineering.
No, it's not.
Mechanics. The same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney.
What
We'd
a
like to
dick.
prepare as well. And if we wait to get
guy
records and
sucks.
information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to
They've already been questioned.
consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
Am I fucked up because I want to hear how this guy explains the scratches on his arm from that taillight?
I feel the
that's
same way.
fucking impossible. I want to hear what kind of bullshit he pulls out of his ass. He
like
welches
with
out of his ass.
Dr. Welcher's report,
Ass Welcher.
what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase,
Dixit.
it's science and data. Quote.
It sounds like Plevin.
Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it.
Get loud.
On a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what
Lots of
Dr.
falsity.
Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration.
Yo, this
and you get
motherfucker
a
is
force.
dope.
And then they said
I'm
this
getting
force
mildly turned on.
is expected to cause or not
I am
cause
too.
these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question's not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Abt-Dalbert factors. So in conclusion, Your Honor, I go back to Rintala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their fourth time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This is the first time that Mr. Alesi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create
What a shithead.
This
to
guy
dehumanize
sucks.
anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times.
You suck.
We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement.
I'd have just called you a fucking liar.
It's purposeful. Attorney Alisi's joining the fray, and that is all part of the
Does
strategy
anyone
here.
recognize
Now,
the irony here?
Yeah,
if you look at
he's
page 13
projecting
and
like a
14 of
motherfucker.
Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583.
She's gonna go to lunch now.
Yeah.
Is there an objection to the Commonwealth's motion limine to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something we need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
Oh,
I
for
can
the
do it
love
in
of
less. You tell me what
No,
Your Honor's
let's
expectations.
see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear quickly from the Commonwealth on its motion.
All right.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing.
Stifle and spanky.
The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that and other testimony that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day, I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages,
Today, Junior! Or the evidence that you're trying to put in under this doctrine.
his niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial other than the fact that we are not going to pursue the Aruba information. So,
So
it
we're
is
gonna-
actually a narrower time window.
We're going to manipulate the niece and nephew again.
All right,
Yeah.
thank you, Mr. Jackson.
Right.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended.
Put these kids through more
or
trauma.
anticipated.
Awesome.
I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points.
Correct.
Hey, Aaron.
That's what I'm getting
What's
to.
up?
With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance.
He's on fire
Even
right
if
now.
he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both CF McCarthy that night, as well as at the waterfall that night, show the two of them getting along
Very well.
completely inconsistent with two people who were talking about breaking up.
Yep.
John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these
Bad
individuals
options.
were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple, out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, "A murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night, or the day before, and she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep.
That was after she dropped him off.
Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision.
It's a very human reaction of a woman.
Statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
No, it's not.
If I could just correct
It's
that.
fucking lies.
If anything Mr. Brennan just said was true, he might have an argument.
Ha! Woo!
It's important to get some of the facts right. You got to get some of them right.
That's a t-shirt.
The conversation that he just referenced with Jen McCabe was the next day.
Yeah.
It was the next morning. not minutes before the collision.
What the fuck are you talking
He's
about?
read the every time he stands up, he says, "I've read the I wasn't there. I read the transcript." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found.
He knows that too.
After
He's
he
just trying to
didn't come home.
confuse.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done.
Yeah.
This was
You can
during
sit-
the time
sit down,
after
Brennan.
Have a
5:07
seat.
After the
Stiffle
SUV
it.
leaves, we see One Meadows and Jen McCabe and Kerry Roberts get together, and as they're looking for them, as they're looking for him and searching for him, that's the point
This
at
is the
which they have the
wildest shit
conversation
ever.
about being about some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other
Look at
issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him?
Will, you look
Come
frozen.
back out when he
Oh, there you
didn't
are.
come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night.
Zero.
Before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out.
That's a
Zero.
relevant time period.
The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? Yeah, I did. You know, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning.
This motherfucker's doubling
When Jen
down.
was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband.
So?
Not my words.
What?
All right.
What a
So
dick.
we're going to break. We've got a lot of ground to still cover.
How does
I
that
suggest
dictate
we
that she
take
was
the
mad?
Personal attacks completely out of this. Hold on. Both sides. I want to get through these
Ooh,
motions
man, I'm
today.
fired
If
up.
you don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's
Well,
focus on the
if he's
motions
lying,
and
you
get
got to
through
call
this.
him
I'll
out.
see everybody at 2.
And she festered it, Will.
As the court ponders the this last issue.
I'm not even thinking about it for the next hour. Let's.
Wow,
No,
dude.
she's eating
Wow,
a
dude.
chicken salad on rye for the
Oh
next
my
hour.
God, dude. Like, can you imagine Alan Jackson and what he's going to be like walking out of that courtroom? You've seen it.
Look at him. They just showed
You've
his
seen
head.
it.
They just showed his head. He looked fucking
Right.
pissed.
Yeah. Alan Jackson gets literally red.
He gets
Like,
red, ears get red, the shoulders get, now I see it with having seen him in person. It's by the way, I've been in court, Will, where I too have been in personal engagements with my adversaries. It's sometimes hard not to, but I just want you to know that the
they're
judge
fucking lying. You
He's-
know what I'm saying? Like, that's gotta be frustrating. Like, it's not just, this is where I imagine Alan Jackson is in his head right now. He's hearing Hank Brennan lie all this time, and now he's lying about something that is easily disproven, and everyone knows it's a lie. Everyone knows that everything that he just stated was a fucking lie. And so at this point, Jackson is in a position to where he's sick of it, but the irony is if he calls him a liar, he's the one being unprofessional.
Right.
That's fucking crazy.
And unfortunately, in my opinion, this judge has thrown gasoline onto just kind of a natural, professional, adversarial relationship between the two. I mean, a trial on a criminal action, it's a sparring event. You naturally are adversaries, but
Right.
her rulings have just completely exploded the level of vitriol between both sides. And I'm going to say it. I'm happy to see that Yannetti, Alessi, and Jackson are all
three of them.
Right. There were instances
Eliza
today.
Little too. You can't take her out of it. They're all like done with the bullshit, hyper fucking laser focused, and not taking any shit. Like, you know what I mean?
Well, I agree. I just, and I think Eliza Little too, but Eliza didn't, from what I observed, didn't have opportunity today to kind of dish it
She didn't
back
have
and
a
show it.
she didn't have a
know?
clash so much with
Clash.
Bev at all. Like she was able to keep her emotions definitely in check, but she was on point. You
Oh,
know what I'm saying?
100%. Best argument from her by
she
far.
hit the ball over the net within bounds each time, you know?
Right. But you got Alessi who got loud. You got AJ who is just not going to tolerate it at all. And even Yannetti who is just dishing it back to the judge. So I was a little concerned last week in light of the judge's stupid admonishment of all of the counsel for making flagrant misrepresentations of a material nature concerning the relationship with ARCA or payment to them. But I thought they would play it real safe and frankly to Karen's detriment a little bit, at least for a time being, but they are not having it, which is good.
They're not. And I would venture to even guess that a little bit of gasoline that got thrown on that fire on the defense team is they're all parents. And knowing now that they're planning on bringing these kids in there to try to trash Karen Reed is infuriating to them. All of them. You should have seen Yannetti when he was being interviewed outside of the courthouse after the kids testified in the last trial. He was like, it was disgusting that they would ever do that and bring those kids up to testify. They had no purpose there. It went nowhere. And there was no reason to put those kids through that. And this is what they're going to do again.
Yeah. And that was a very important motion, just so you all understand. Normally evidence of someone's state of mind won't come into evidence because it's hearsay. It's an out of court statement, right? But in this instance, there's another layer to it, which is the person whose state of mind it was is deceased. So now it seems apparent, at least to me, and maybe to your astute audience, that the prosecution is looking to abandon the Aruba theory, which was always questionable, and to now use, and I'm intentionally using the word use, both children, the niece
Yeah.
and nephew, to shoehorn a motive together, that they were having, I forget what the word he used, tumult, I believe it was. There was tumult in this relationship. And that's
Right.
why the time period of the state of mind of the decedent, the dead person, is important, because if things happened the next day, if Jen McCabe has formulated her intentional opinion, thank you, petty paralegal. If Jen McCabe by the next morning, after I dare say a sleepless night, is now in full cover-up mode, talking to any police officer, law enforcement officer with a heartbeat as to what her spin on this story is, and after Googling at 2:27 a.m., what she's telling officers, or what she's telling any friends in the know, in the circle or beyond, as to what the decedent's state of mind was, that is all irrelevant. So if they're going to look, and this is why it's kind of subtle, but it's important.
Well, the thing is timelines have already been established, and the most crucial part that Brennan is trying to twist is all on video. You know what I'm saying? Like, you can't know just because. Okay, so now what he does is he doubles down with something weak as shit and says, oh, well, we're passing by an ex-girlfriend's house to get to 34 Fairview.
Yeah.
That's it. No expression of her feelings about it, nothing, just that fact. And then counting on Judge Bev to assume that Karen Reed was angry about it.
Yeah, and I have a sneaking suspicion Karen didn't give two shits about that
I
ex-girlfriend.
don't think so either. Yeah.
Not, certainly not enough
No.
detail, but I mean, I'm
And-
guessing, but she didn't strike me as that.
And another interesting fact to take into consideration here is when they were actually having trouble via text message, she was the one being consistently sweet. She was the one making the effort and being classy. John was the one being cold and distant. That's get mad at me all you want, but I know what I fucking read. You know what I mean? And he had said he'd been drinking all day. So
oh, sorry, Will.
She was just desperate to find some sort of common ground because she wanted to know, how do I not, you're too important to me. How do I not cross the line with the kids? How do we, because I don't want to make you angry with that. And I don't want to overstep my boundaries with them.
Oh,
You know,
I
that's
agree.
all that was. She was making a very classy and very mature effort to do this.
Yeah, I mean, even if the Sullivan sluts were important at this point, which they're not, it doesn't seem like they're. This is a good question, by the way. But even if the Sullivan sluts were still in the picture, Karen even offered to or paid for their dinner, or she offered to kind of make amends after a little tiff as to whatever happened in the lobby of that hotel. But I saw this super chat come in, Will, and I thought it was important because you and I were communicating when, I know you try to provide an uninterrupted stream of these proceedings for your audience, which I have to say, as somebody who is
Oh, was there one before this one?
Well, if there is, wait, hold on.
No, we're good.
Okay, I think your audience really gravitates towards not a lot of interruptions. We were communicating about this very issue with Karen's defense team recently adding to question. Karen's defense team was recently added to the Commonwealth's witness list. Is that normal? Why would they add them? The answer to that is it's not normal. They also added, from what I was told, wait, hold on. Somebody told me that. I can't remember. I thought they also added her father, and the chat can correct me. I hope you appreciate we're kind of multitasking at this point. But these types of amendments to witness lists, that's not uncommon. But to add attorneys especially when you put
This
your
is the
first.
craziest shit I have
It
ever
is.
seen,
And
man.
adding Morrissey, right? So Morrissey is on the defense list, and that could have been anticipated. He is deep in the butthole of this case, and I
could specify this simply for the hostage video. He is prone to being called to the stand.
right, and they have every right to hammer him back and forth, and even on, I think it was your stream yesterday, where I said I would, if I were the defense, I would call Morrissey last as a witness and just
Sure.
him with all of those lies. He's the prosecutor for that county. All of the lies in that 2023 hostage video. But
Wait, let me check my crystal ball real quick for Michael Morrissey's testimony. Hold on. I've got it.
I have a secret document that I think you need to say.
That's it right there.
This is why I love Mommy's Glarer time. It's so appropriate. But he was anticipated. I thought he was going to be on the list. But to now think of your timeline here. Now you have, yes, the defense list came out, I believe, yesterday, maybe the day before. Defense witness list. Then you have former trooper. What is he called now? Just Mr. Proctor. You had a nickname for him. Douchebag or something. I don't know. Whatever you're going to call Proctor now. But
I called him a douche nozzle, I think, on Twitter. But that's a pretty common insult.
He was terminated yesterday. So now you have this drop, which, by the way, was posted by Jim, the inept court clerk, lightning fast. But you have now.
Yeah, like shit was. What the fuck was going on there? Like that shit happened while these proceedings were happening.
Right. But meanwhile, the defense properly submitted theirs last week, and Jim didn't get around to posting it for days. There is quite a conspiracy going on, my folks. But anyway, this was done quite intentionally in a retaliatory fashion, as far as I'm concerned. Karen.
I was just going to say that. Is it something that simple? Because that seems to be the only logical explanation, which isn't very logical, by the way. But that, because they're calling Morrissey to the stand, and that defense list came out yesterday. Now they're like, oh, well, okay, they're going to call Morrissey to the stand. We'll call you guys to the stand. How about that?
Yeah.
How about that?
Yeah, what I would forecast on to your audience is that
hey, Kelly, your girl, she just gifted 5 members. Thank you, Kelly.
Thank you, Kelly. What I would forecast to your audience is the defense attorneys now having the unusual circumstance of being added to a Commonwealth witness list. They are going to file a motion to compel or to force a proffer, PROFFER, from the Commonwealth as to the substance of what is being asked of them, because there is an ethics rule that governs attorneys, which says you can't represent someone if you're going to be a fact witness on their behalf or in a case involving them. So for them to give testimony on a case where they represent her inherently violates ethics rules. So it is incumbent upon the defense, as far as I'm concerned, to file asking for a proffer from the Commonwealth, setting forth, what do you want to ask us? I suspect that the Commonwealth wants to ask those attorneys as witnesses, questions concerning any communications they had with ARCA and possibly any communications they had with Aiden. That's my suspicion. I also don't know if Bev would grant a motion for that proffer, but we'll see. Will, if you put another super chat up, that was beyond that question. I don't know if I saw it.
No.
Oh, okay.
The prior girlfriend thing, we just did that.
Oh, okay. But also, as far as you and I, or at some point, I'm gonna have to understand what asswelcher means, or because I missed that. I walked away, so I wasn't.
You know what's really funny is like the only reason that came to mind, because it doesn't make any sense to anybody. The only reason that came to mind is because I actually knew somebody. Me and my friends, I'm still friends with these guys, actually. Growing up, we knew somebody with the last name Welch a long time ago. And
You
that
call him
person,
asswelcher?
and then yeah, we would say asswelcher. And just busting balls, you know what I mean? Like nothing.
Oh,
You
and
know,
what is
we
felch?
love this person. We absolutely love this person.
What is felch?
But this dude's name is Welcher, so I just started saying ass Welcher because I guess the habit is still subconsciously in there from being a child.
But what is your audience is asking you to tell me what felching is, because I think I missed that too.
Felch, I don't know what felt. That's the only time I've ever heard that word, honestly, is from Gangs of New York.
Oh,
Yeah, where he was like, "Are you calling us felchers?"
someone posted in your chat, is that a dog or a cat of mine? That's my 80-pound Bernedoodle Roselle.
Kelly says, "Making it up to you for this morning. I couldn't do you fast enough when I found it. Sorry, Will. Oh, you're good. Thank you.
Kelly didn't
Appreciate
do you
it.
fast enough, Will? Is Kelly
Oh my
beating you?
God. Yeah,
Nice.
apparently.
Yeah. So
Yeah, via email.
I love it.
She welches the shit out of my email.
That sounds sexual. Anyway, as
Hey,
far
man,
as
if my
far as
answers frighten you, you should cease asking scary questions.
as far as the Judd the Chud motion, I mean, Alessi, as boring as I understand his arguments are to most of your audience, it was a very well written, argued motion on behalf of Alessi. That this is a classic type of argument where the expert who is put forth by the Commonwealth isn't qualified, and his report fails on its face because he did not tie his methodology to his opinions. And he doesn't have a methodology because there's nothing published that he would have relied upon that specifically supports his methodology. That's it in a nutshell.
Dude, Alessi turned into the legal Incredible Hulk.
Oh, yeah.
Like
And
out of nowhere. Like he just hulked the fuck out and then started like explaining basic fucking Newton laws and shit. Like, this is what you do. What do you, there's not even that shit in there. It was beautiful. Meatball Morris, he's kidding. Do not tell Nan what felch is. Do not corrupt our Nan. I don't even know what the fuck it is.
Thank you, Meatball Morrissey Skitty. I think, unfortunately, I might be.
Oh my God. Does it again, Kelly.
Boom.
Oh my God.
That's so great. I wouldn't even know how to gift a membership. Maybe I need to check how I do that. But as far as that Welcher motion is concerned, you've got Alessi coming in who made the just most unsupported arguments. It was basically the converse of, he was taking a converse position to how he argued against Dr. Marie Russell coming into evidence. And of course, the judge reserved decision. So, it's an important issue. And with her not moving the April 1st trial date, like, shit's got to happen. I don't know what she's sitting on.
This is crazy.
These are types of, like, when you get to the in limine motion phase, shit happens rapid fire. Like, motions are, I have filed in limine motions the night before trial, the morning of trial, and that's okay. But the judge decides immediately. That's what trial judges are supposed to do. But she's going to go reserve, do whatever it is she does in her chambers or in her personal life.
But it's still got to start by April 1st. No matter what, it's still got to start April 1st, even though she's not doing what you're describing,
right?
What every other judge would fucking do.
And
Amazing.
you know, that whole bullshit with I'm gonna need the ARCA guys to come in for a voir dire from out of state, you know, but yet she won't issue any type of ruling or give any commentary about Crosby and Gilman, and I think there's another guy. Like,
Of course, Bev is up to something. She absolutely has an agenda. Let's just cut through the bullshit
agreed.
real quick. Let's just cut through the bullshit real quick. We'll get to your question in just a second, but I don't want to lose this thought. The fact is that right now, and I don't know if that's fact. I'm just saying I got a pretty good nose for these things. And I'm looking at the comment, or I'm looking at Karen Reed's defense. You got to understand these wonderful people, this team of rock stars are working for free right now.
Yeah.
And they're doing it because it's the right thing to do, because their hearts are telling them, if I walk away from this, I'm a piece of shit. I'm going to hell.
Yeah.
You know what I mean? That's what they're thinking, probably. Most likely. That's the only thing I
Right.
can imagine, because you got to take this into perspective. This is family time. Pro bono fucking shit. This working for free when they're not used to working for free.
Right.
That's family time.
But it's
AJ has
also
a family on the other side of the country.
it's also
You don't-
other billable hour time too, as we've discussed. They could be working on
course.
paying
They
client
could be
members.
working on another case and making more money too. They could be, this is time that is being robbed from them.
Yep.
And Bev is responsible. And I think
Yes.
that that has a shit ton to do with them losing their patience right now. Not that they're losing money, but the fact that I mean, yes, in a way, losing money, but they're happy to do this for the right reasons, is what I'm saying.
Right.
But the fact that they're so driven, that mix of that passion that's driving them to do this for free, but the fact that they're missing time with at least time with their families is got to be getting to them by now. It's got to be.
100%. And then when you have Bev say things like, well, we'll bring you back tomorrow, and if we have to bring you back Monday, we'll do like that's when AJ
Right.
kinda lost his shit. That means
That's
he's got
what I
to
was
stay
thinking.
there over the weekend. And, you know, it's exactly
Right.
what you're saying. These are examples of how,
And
like,
it's all her.
It's all
you know
her.
what I mean? It's all her. She's allowing this farce to go on. So
Right.
each time that Brennan stands up there and blatantly fucking lies over and over and over again, after getting lectured about from her to that I will not tolerate mistruths in my courtroom. And then this guy does it over and over and over again, and she just lets it go, holds his hand, walks him through shit, interrupts the defense every time they're going to say something or they're getting in their momentum about to make their point.
Right.
It's infuriating on every level right now for the defense.
And I
It
feel
has
it.
to be.
I feel it for them because I know I would be. And, you know, I do out of state matters. I get brought in for things. So I have that firsthand experience where I'm like, I got to come back.
Thank you, Scott. Appreciate you, buddy. Scott
And
Messerschmidt.
even like from my experience, like I'm licensed in New York as well. There's times I've had to drive up to Rochester, New York, which is nowhere near where I live, or Albany, which is probably 3 hours or so from where I live. And because the tribunal may not have handled scheduling properly or arguments went too long, I've had to leave and come back or make last minute hotel and you know, some state issues I've had or circumstances I've had to make new flight arrangements. And no, I don't fly to Albany. But the point is, it's an inconvenience to all. It's also an inconvenience to Karen, and
of course
the tax. So on in limine motion type of days, and it's not always over one day, but the judge normally kind of truncates arguments and cuts through that bullshit. There were plenty of times where I understand the attorneys need to make their record, and especially the defense does in light of all of the Brady violations and the extraordinary misconduct. But the judge could have kind of said, I've heard enough. I thank you for your argument. Do you want to rest on your papers? I have enough now. I've heard enough where I can make my decision. But she lets them go on and on and on, thinking about her corned beef and hash that she's going to have for lunch. And here you are. It's going to be the afternoon.
She's thinking about her Tito's that she's got to refill her fucking water bottle with.
Oh, I was going to say, you know,
That's my only. I mean, that's it. Like, she's got to be drunk, dude. She's either got to be drunk or she's just fucking like, or she's just a piece of shit.
I don't
Either
know.
one. I don't.
White Claws, living the mom life said. That's so funny. You guys are, oh, by the way, hi, Scott. You did so great. You and Dina both did so great on Justice Served. And I
Yeah.
think it's worth mentioning because I don't think I had a chance to post it on X. If anyone hasn't listened to Justice Served, their latter program, the one that aired like into the evening, I think it actually overlapped with yours, Will. Their program was so
Yeah,
good.
I meant to actually direct people over there, and I forgot to when I ended my stream yesterday.
They really did a great job, and they were taking shots at Proctor, which I find very refreshing because I know that you know, well, first off, they went obviously did a very good legal analysis of it, but they're both hitting the point where they recognize the hackorama, which I'm here for, and I find that very comforting when I see it in other attorneys because while I'm not
And
the
Linda,
first, yeah.
Linda's husband, Linda, the female co-host there, her husband is the medical examiner that was independently hired that determined that Sandra Birchmore was murdered and did not commit suicide, which is a big deal.
Yeah.
That's huge.
It
Here's
is
here's their channel link. So go subscribe to them.
Yeah,
They're fantastic.
All of their programs and coverage are great. Michael Bryant.
I'll be right back.
Yeah, sure. Michael Bryant of their team has gone up to Canton from Connecticut several times. And you know, I know we've talked about this previously, but he is really excellent. But their stream that they aired, I think there were maybe two yesterday. The stream that they aired in the evening last night, especially, was so good. And for anyone who really wanted to get a strong kind of sense of comfort from the termination of Proctor, it's worth a view. Like they're really good at what they do, and they're going to grow. And if anyone does watch them, make sure to help their algorithm, like their videos, you know, subscribe, which doesn't cost anything. And no, this is not a paid advertisement for Justice Served. So anyway, while Will is probably eating a glazed donut, I wanted to just let you all know if I'm just going to talk a little bit about motions while you're probably eating your lunches and such. But if anyone has a question for me, try to put it in caps in the chat because I don't control super chats or any of that stuff. Oh, he's back. Good. But as far as these motions are concerned, there was another one that I wanted to mention because she kind of went through the issue of the Celebrate demonstration by Ian Whiffen, which was unopposed last time and did not get to be argued yet this time. They're going to, but because I don't know who it was, maybe it was Yannetti or Alessi said, I need about 20 minutes. She said, well, we'll get to it later then. But that is going to be an issue to watch because I'm confident the Celebrate demonstration is going to be different this time because they really need to try to convince you that the 227 search didn't happen. But I'm seeing, Will, I told people to put things in all caps, and now I probably regret doing that because the chat flies. But could AJ gain license to practice in Massachusetts? Yes, he could, but that would not overrule or bypass the judge's ruling that, you know, he committed, allegedly, in my opinion, but he committed some type of material misrepresentation to the court. So even if he got admitted in Massachusetts, I don't necessarily see that would get him around her ruling. Like she's already found him to have misstepped, which I disagree with. Kathy Bennis says, I thought Bev let Arca in. She did, but now again, without pleadings, we have Brennan saying, well, I want to voir dire them. They're not qualified enough. Or I want to ask them questions about what the feds sent them and what the communications were between the feds and them and the defense team. He's on a fishing expedition. And I do believe, and Will, you said it earlier, I do believe that it is Morrissey. He's trying to sniff around to try to find out exactly what the feds were looking at. And I still think the feds are looking at it. That's always implicit in what I'm telling you all. Don't mind me. I'm still just looking to see if anyone has questions. But I don't think so. So, you know, I don't know how to run a channel, nor will I ever. So, you know, give some grace. Oh, thank you, Southeast Sally. But then also the judge, it does appear there were no objections to allowing the use of chalks or demonstratives. If I didn't catch what motion number that was, but it seemed like no one was objecting to that. And maybe that's too overbroad of a description, but it was kind of flying in terms of she wanted the lesser motions in. We talked about Judd the Chud. That's important. You know, he's not a medical expert. He's a biomechanical engineer. And, you know, you heard Brennan, and it's probably worth mentioning because Brennan said it at least 3 times. He keeps kind of making an issue out of why the defense did not call all 3 guys, Rentschler, Wolf, and Klein from ARCA. And I'll tell you why he didn't. Like, there's nothing there. It was to fucking save time and expense for everybody. If they could have, and even Bev, if I recall, and I have a better memory than Judge Bev does about that case. But if you do recall, like even Bev was like, do you need to call all 3, Mr. Jackson? And he's like, well, you know, I'll have to speak with them. Maybe I need to get my bangs out and while I do my impersonation of her. But, you know, he's like, well, I'll have to speak with them. So he did what every good trial lawyer does, which is to kind of truncate any redundancies. So I'm telling you guys, like, there's no secret or something like some aha moment that they didn't call the 3rd guy from ARCA. You know, if you're barking up that tree, Brennan, you're barking up the wrong tree. And I see there's some other caps, so I'm going to check that. There was, and I will check it, but there was also the motion, I think it was 575, to appoint the stenographer, which is common, and that's not opposed, to impound the jurors' names and info. That's also routinely granted, although, you know, it seems like both sides were kind of disputing that a little bit. But Yannetti made a big issue out of the sidebars because he wants the sidebars not impounded for judicial economy, for public transparency. I get it. You have a sidebar during a trial. You don't want everyone to know what's being discussed at that time, but you also especially don't want the jury to know what's being discussed. So if you don't want the jury to know, that's fine, but there's no reason that the sidebars need to be impounded. Because now, yeah, I'm getting better. It's kind of okay. So I think I know my notes are a little truncated because I'm really multitasking today. Also, if anyone heard me typing, I apologize. I'm literally working 2 jobs right now. So anyway, I saw some more questions, Will, if you want me to hit them, but it's your show.
Really? What?
Yeah, it is your
Where'd
show.
you see them? Where'd you see questions?
Oh, well, I had asked everyone to put in the chat.
I saw somebody
there's
say
like
butthole.
Lawleen had one. Could the defense team being added to the witness list have to do with the ID documentary with Karen and media being there breaking confidentiality about stuff that was discussed? Well, first, I still haven't seen anything beyond the first episode, so I don't officially know if I can meaningfully answer this question, but it's possible, Lawleen. I mean, if this
Lawleen,
this is the this is Brennan's quote methodology, just to kneecap the defense. So if they feel, the Commonwealth feels that there's anything that needs to be uncovered from some type of like inadvertent slip, like something was said by Karen or her defense team, or that he's going to go that route. That to me is completely, it undermines what any prosecution should do, which is just to get to the truth, present the truth. And how many fucking times today, Will, did you hear Brennan say this is about being transparent and we want to have a fair trial?
Yeah, that's how he covers up his lies.
Yeah, it's like he's sleazier than Jen McCabe now in my book.
So bad. Yeah, like this guy is fucking just will lie and lie to make to sell his lies.
Yeah.
And it's shameless, and he does it with ease. And it's the slimiest shit in the world.
It is, and oh, hi Microdots. I'm a big fan of yours. I love your work. I have to join your Patreon though. I keep telling myself I will do it, and I don't know how Patreon actually works, but I will. There was another question by ProHawk VJ. By the way, I almost named my son Hawk. Yeah, we're big into like unusual names in my family. So ProHawk,
are you into like is that because of Over the Top?
Yes.
Right? Get the fuck out of here.
It is one of my favorite movies.
Lincoln Hawk. Get the fuck out of here, bro. Yeah, that's my shit right there.
That's one of the reasons why I also
The world meets nobody halfway. You want some? You got a ticket, Mikey. You got a ticket.
But I feel so
my shit, bro.
I feel so seen right now because this has been one of the reasons why I've been a big fan of yours, is your Stallone affinity, which by the way, another big Stallone movie that I'm a huge fan of is, I think it's called Cobra.
Cobra, of course, Cobretti, bro. Get
Yeah.
the fuck out of here, dog.
Yeah, love that.
That sequel.
That movie used to scare me as
long as Sylvester Stallone is alive. I want a Tango and Cash sequel. I want a Cobra sequel. I want a Lockup sequel. Everything.
Yeah, Lockup.
Yeah, Lockup was my shit, bro. Tom Sizemore was awesome in that movie.
I loved that movie, and I mean, there's so many of his. But you know, as you know, the Rocky movies.
Okay.
What are we?
Hey, people love to yell.
Oh, are people? Yeah. No. I told them, Will, to put them in their all. I told them to, but
so you instructed my chat to spam it. That's great. Thank you. Man.
No, I told them to put it in the regular, not to send it super chat while you fucking visit me on your goddamn channel.
I can check them.
So. Okay, is it impossible for John's temperature to be at 80 degrees if he had been outside since 12:30 a.m.? Why doesn't the defense have an expert to testify this temperature would have been much lower? Well, I think the defense will have an expert to say.
They probably will, yeah.
Yeah, we don't, Kelly, we don't have access to their reports. So I imagine that while I don't believe that was emphasized during 1.0, I think it is the issue of his body temperature at the time he was found, not correlating with the alleged time of the incident, which again, moving target. Like, people should be looking at Aiden's text today, because he always brings the receipts. And Will, it might be helpful to you if you wanted to go over any of them, but it's definitely the timeline that the Commonwealth keeps marrying themselves to is going to come and bite them in the behind. But he's
just like, it's crazy. He's just throwing fucking mud at the wall and hoping it sticks with these motions. Some of these motions aren't even consistent with his strategy to go forward. It's so weird.
You know, I agree, but I've been saying to you over the course of our what feels like a long relationship, but it hasn't been a long relationship. I've been saying to you throughout that that the prosecution has to prove its theory and it's this case. So they can't, like, even 1.0, Lally had some timeline in his opening statement. He was saying like 12:45 is when this happened. And then as the case went on, it kept changing. When can you drill down this accident as having happened? You don't need to know the exact time, but if you were, as an audience and trial viewers and people who assiduously follow this case, are to sit down and say to yourselves, okay, well, when did she connect to Wi-Fi? So if that was 12:36, I believe, today Brennan was saying something about 12:30 or 12:32. I apologize, I don't have all of it in my notes because I'm multitasking. Then you have people who pulled up to that scene, and I'm forgetting all of their names, but people who pulled up and didn't see, they saw Karen, but they didn't see John in the car. Then there were Jen McCabe at some point was texting John O'Keefe at a particular time. Then she was texting or testified that she looked out the window around 12:45. Then there are records of like a 12:29 phone call from Karen to John. So if there was a 12:29 phone call from Karen to John, was she fucking calling him right next to her? I mean,
Right.
and guess what? Like, I'm being facetious when I say this, but if I wouldn't be shocked if Brennan says yes, she called him while he was sitting next to her because they had tumult in their relationship, Your Honor. Sound like an old vaudeville comedian or something, but the point is, like, he's going with this. But anyway, before this carries on, because I'm probably word salading your audience, I did want to just specifically answer Pro Hawk VJ because I mentioned his or her name. Why do you think Bev doesn't call out Brennan on his flagrant hyperbole? Bias.
Hyperbole.
Yeah. Will can't pronounce hyperbole, surreptitious, sorry, I'm hitting my wires. Prima facie. There's some others which is very charming, by the way.
Oh, it's charming. That's cute.
Yeah.
It's charming. That's it. Okay.
I'm retarded?
That's hysterical. By the way, you know what's funny? As I've been sitting here,
Dorchester, exactly.
I've gotten 3 law students from Massachusetts have sent me emails to be my summer associate. I'm like, guys, you realize I haven't written them back, but like, I don't
Send them to me. I got it.
I don't live near you guys, but yeah,
Listen,
I will.
Retainer. Okay.
No, these are associates. Will. They want to work. They want to work for.
That's what I'm saying. Just listen.
How about you come?
They gotta pay for an internship with me. They gotta drop a retainer. All right.
That's
Keep
so
the ear
funny.
to the grindstone. Okay.
I think you would be an excellent boss. I really
send
do.
them to me, dude. I'll teach them everything they need to know about the law. It is very, very simple. Listen, object, sustained, you're done.
Yeah, I agree. I'm looking for other caps in these comments. McKingston 1, it was filmed before the gag order. No, I'm trying to remember where in the timeline of the chat you would have written that. I don't understand your question, McKingston 1, but if you ask it again, and I'm only looking for all caps.
And I'll take care of it because, listen, Gallagher Law School is now in session. Okay?
Yeah, I don't know how you streamers do this all day. Like, this is hard to stream hearings all day. I hope I'm doing an okay job, Mr. Gallagher. I hope I am.
Listen, ain't nothing but a thing.
Ain't nothing but it. You guys should understand at least that show Will some appreciation. He's very good at this.
Ain't
I saw Kelly's chat. Oh, I'm seeing question marks, but not all caps. You guys got to shout them out because I'm blind. All right, let's see. Oh, so it's probably worth mentioning if I'm getting current with your chats and I'm stopping. Let me stop where we're current. Okay. Oh, well, I'm not going to answer that question. Does the Gallagher have okay. Yeah. Does the Gallagher have a crush? Yeah, I think he does on Clubber.
No orange crush
Chicago.
for me today. Just the chock full of nuts.
So this is
That's a lot of flavor.
This is worth mentioning. Okay. The issue of, because I didn't hear a lot of people discuss it. I heard one streamer discuss it, but it didn't hear it discussed a lot yesterday. There was, with the firing of Proctor yesterday, there's been a lot of banter about whether or not that comes into evidence. So please allow me to explain it to you. Whether he got terminated. Oh, by the way, I believe he was added to the amended witness list. So I think it was him, from what I was reported to me, the defense team, and I think I heard Karen's father being added. The chat can correct me if I'm wrong. Oh, thank you. Shut up, Chrissy. But please, if you have your go-to for the breakdown with Melanie, don't let me keep you. This can be word salad. Although you'll have more fun with me today because I'm in a mood. But anyway,
that's the amended Commonwealth witness list.
Oh dear Lord! Can you make it larger, Mr. Glenn?
I might be able to.
I need it. I need it larger.
Right after I enjoy this cup of hot Stevie Joe.
This segment is brought to you by Chock full of Nutsacks. Okay. I can't read.
Oh my God. Hold on a second here. There we go.
Oh, swear
in the
jar.
pot, people. In the pot.
We're gonna have a fun lunch. All right.
That's the best
pull it
I
over
can
on
do.
the screen. Albert's.
I could screenshot it and send it to you.
No, I'm fine. And I'm looking at it on a large screen now. So
Oh, okay.
Okay. So where are we? Fact witnesses. What do we got there? Read. Okay, that is funny. All right.
Make it bigger, Glare.
Gay. I need it larger.
Oh my God.
All right. Yep, Bill Reed was added.
I need you to stop with that shit.
Am I going to get you demonetized?
Totally. That's totally going to happen.
Oh, I have to say, YouTube should be happy that such a law mama is saying that and bringing some attention to the stream. But anyway, I'll clean it up.
Yes. Digress by all means.
All right, Bill Reed was added. Then,
okay.
What do we have? Jackson. What do we got there? Law enforcement. I hate how they order. Oh yeah, counsel for defendant Jackson Little Yannetti down on the bottom right. And who was the other one? Proctor, law enforcement. Was he added?
He was already on the list. No, wait. No, I'm thinking something else. Go ahead.
Yeah, he's on the list now.
But he's on the list now?
Number 64.
I see it.
So Bill Reed is at number 30. Proctor is number 64. And counsel for defendant Jackson Little Yannetti, not Alessi.
And Higgins is on the list, number 14.
But I thought Higgins was already on the list.
Okay, I wasn't sure.
Yeah,
just checking to see if you're on your toes over here, Nan.
Oh, sorry. Okay? Yeah. So anyway,
Welch ass on your own time.
Don't make me felcher. I don't know what felcher means.
I don't know what it means either. I don't have any
All right.
idea.
So anyway, I've seen enough of this list.
Okay.
I want to see your coffee.
My
Oh,
coffee.
Scorty Bello. Scorty Bello is added. Thank you to whomever just wrote that.
Scorty Bello was added. Beautiful.
Okay. Well, I can't tell you guys if it was an oversight. Where the fuck are you? Where did you go?
You just calm down. Everybody can still hear you.
Oh, sorry. Where's the glare on a break? Yeah. What is going on? Oh, okay. There we go. So anyway, this is something that's worth mentioning to your audience as far as Proctor getting terminated. There are rules of evidence that would not necessarily allow that to come into evidence, whether or not he has been terminated or committed misconduct. There are evidence rules that...
I'm sorry. Go ahead.
Yeah, sorry. No, that's totally fine. So there's evidence rules that would prohibit that from, in some instances, coming into evidence.
Is there something wrong? Sorry.
Oh, shit. But anyway.
Okay. I'm done.
So, I was making some notes this morning on it because when that type of, it would suck. I guess what I would tell your audience is, wouldn't it colossally suck if Trooper Proctor, former Trooper Proctor, got fired for misconduct among other items, and then Bev makes a decision to not allow it in? It takes the aha moment out of cross-examining him. We want that as free Karen Reed movers and supporters. So we also want it, in my opinion, as Turtle Boy supporters, for any of you who are watching who support Turtle Boy. With all of that said, there are cases and evidence rules which weigh heavily in the defense, meaning Karen Reed's favor, which would allow that evidence of his misconduct, which is a prior bad act, and his termination, which is arguably an adverse decision of a tribunal, or you could equate it, if you wanted to like a criminal conviction, that weigh in the favor of allowing the defense to admit that evidence. And the relevant considerations are, so if you guys are talking about this with your friends as to whether or not it comes into evidence, and I do anticipate that one of the sides is going to either file an in limine motion to bar it or to admit it. There's going to be a filing to address Trooper Proctor's termination. It might come up this afternoon.
Yeah.
I want to just give you a heads up. I'm gonna have to hop off around 3-ish because mommy has to get the kitties.
Okay.
But I would be in your chat because why not? Anyway, when you consider his termination and his prior misconduct, just understand, and someone asked, can the defense add Lally? Sure they can, and maybe they will. It's so unheard of that I feel like I'm kind of giving advice on things that never happen. But in terms of his Proctor's termination, was the termination or misconduct material to this issue, this case? And it was. It's not like, well, he was terminated or he was disciplined 5 years earlier for other reasons. No, he was terminated partially, if not heavily, because of his investigation of the Karen Reed matter.
Like they kind of specified, like it's funny because they use that article, which the investigation falls under that, but they specified that it was the text messages and the going out and drinking with Kevin Albert, but they didn't even name Kevin Albert.
Well, there's more to it. There were more findings. I don't know if you've seen the other document, Will, which may or may not be in a drive, but
I had 2 pages.
Hold on.
Total. I had 2 pages total.
This is one of the reasons why also Justice Served did a great job kind of shitting on Proctor last night, because Proctor, hold on, might be here in the drive. Pardon the dead time to your audience. I'm unable to talk and to read at the same time. Proctor family personnel order. Yeah. It's in the drive. So there is the personnel order, which I'm happy to just read it, but if your audience wants to hear it, but there was a personnel order from the Department of State Police, which was published, and they made various findings. And in terms of the findings, one of them that they discussed was actually that is some of his conduct, or on one of the findings that he exhibited bias in this investigation. That's key. There was bias.
Okay. But that could still fall under him having personal feelings about Karen Reed, which he showed
Right.
in those text messages. See what I'm saying?
That's correct. But all of this, and it's worth, if you haven't looked at this personnel order, maybe I could email it to you if you can't see it in the drive, but it's
I can't.
all right, hold on one second.
I don't know why my drive doesn't like update. Because I downloaded the app and everything. I'm like signed in.
Let me just text someone. Can you? And you went into shared with me. There's something called shared with me. Can you email?
Maybe.
Proctor personnel order to Will. All right. So while we're getting you hands on that document, the other issues that come into play with this. Oops, hold on. I don't know what came through. Okay. The other issues are, was it material to this case? Which it is. He was disciplined and ultimately terminated because of his conduct.
Due to his conduct in this case, specifically.
Right. And is it as to a critical issue? And that's also a factor to consider. And yes, he was terminated because of, among other reasons, very critical issues relevant to this case. The case law also talks about whether, if this evidence of his termination or misconduct would have a significant impact on this case. Would it have been important, or would it be important for a jury to consider? The answer to that is also a resounding yes, no matter what Brennan tries to argue in the future. In addition, it is first let me say this. There are factors the court, within her discretion, which I hate giving Judge Bev any level of discretion because we know which way she tilts, but it is within the court's discretion to consider, the age of the evidence. And
this is what I have. I've
Okay.
got it. Yeah, this is what I have.
Okay, because there's also another 2-page document that I thought you were referring to. But also the judge has to consider how old this bad act was, or this termination was, and he was fired yesterday, so it ain't old. The strength of the evidence, which this is strong. This goes towards bias and impeachment right from the outset of the investigation of Karen Reed and the death of Officer John O'Keefe. How probative, or how strong and potent to prove points this evidence would be. This is also going to be a box that gets checked. In addition, is there bias or prejudice to be considered? The judge has to consider that. It's within her discretion to do so. I really would be absolutely shocked if Bev does not allow evidence of Proctor's termination and his misconduct and into evidence, whether it's for impeachment only. See, I
mean, I wouldn't put it past her for the same exact reasons why she wants to block the information that the feds hired Arca. Like, there's no logical reason behind that, and yet she's doing it anyway.
But I will say this, and maybe they'll argue it unbriefed this afternoon. I will say this. If she does not allow in, and by the way, there's tons of cases that even say, Like while the judge has discretion, the case law shepherds the judge strongly in one direction. So if she decides to ignore years of case law and evidence rules and just says, no, I'm not going to allow it in. If Karen is convicted, this will be a huge feather in her cap in terms of an appeal. So I never
Right.
like to think about that. But whenever there's a situation, holy shit, has it been an hour?
Yeah. It's about to start again.
Fuck, I can talk a long time.
The feed came back.
Well, maybe you want to go over some of Aiden's tweets while I go let my dog outside and grab snacks.
Yeah, sure.
Okay for
Of
you?
course. Sure. Yes.
Mommy needs snacks. All right.
Oh.
I'll be back in a few. Aiden's tweets were good. I'm trying to think if anything else came out today, but I don't know.
Let's check them out. All right, we'll see you in a bit, man.
Back. Bye.
Bye. Right. See what we got here. What in the? All right. So yeah, Turtle Boy reposted. Hold on. Never mind. He said, the enormous woman sitting next to Peggy O'Keefe is nodding her head no, as Alan Jackson says that Karen Reed and OJO were lovey-dovey the night he was killed. Yes, well, the enormous woman would be wrong because they were lovey-dovey because security footage dictates this. Spanky claims that John O'Keefe's state of mind is that he wanted to end the relationship with Karen Reed. Fact check. He repeatedly asked her to come to Canton to drive him around and wanted to get snowed in with her until Monday. That's right. 742. Why you're not coming? 832. I'm just reading the underlined ones. Figured you'd be in Canton till Monday. I'll head up there in a few minutes. Let me know if you leave. Sure. Let's see. So let's read the whole conversation. Karen says, okay, let me know if you end up leaving. John O'Keefe, why? You're not coming? Karen Reed, I'm waiting for the plumber. I actually think he's in the driveway. John O'Keefe, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. Karen Reed, he's not going home after? John O'Keefe, 8 p.m. on a Friday. He may have to get Michael. You have a plumber coming over at 8, knowing me and Pap could have handled it. Good luck. Like, you see what I mean? Like, he was kind of being a dick that day, dude. That's 7:44 p.m. And then 8:29 p.m. she says, yeah, but he lives right down the road. And then he's like, at 8:30, he says, Karen, this storm is going to be intense. Can't drive. Karen says, okay, well, if he can't, he can't. And then he says, I'll do it Monday. She says, better not still have this problem on Monday. And then he said, you plan on being there? And then she says, I'd like to know.
And
I can take
do it.
a hot shower if I need
Some
to.
time
And he says, figured you'd be in Canton until Monday.
Dear, so I don't want
Like, there's nothing in this conversation.
that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a juror questionnaire?
I know you asked us, so we have not. We haven't.
All right, so today's the final trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
Wow.
I want the court to be super, super clear about what Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling
Why
John
is Paul
saying, "Where you work
smirking?
interview is down the street from Ashley's house." My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Right.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I
that
understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
all
That's clear. Thank you.
All
Yeah,
right,
like, let him
well,
make
Mr.
his
Jackson,
point.
You can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you get 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right, so I'll hear you on your motion,
Woo!
Mr. Brennan, and then a 2-minute response.
Love it. This is the not fucking around defense, people.
Jimmy, keep track, please. Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See,
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Mr.
Wow,
Yannetti.
amazing. She cut off Brennan. That never happens.
This is bullshit. This it's motions in limine by speed dating.
Your Honor, I can't
Yeah.
do this in 2 minutes.
Right. There you go.
We'll hold it. We'll
That's
hold
fine.
it to the end.
That's fine.
Yo, Yannetti's sick of this shit,
Mr.
dude. Look at him.
Leslie, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
This is crazy. This is a fucking circus. While I got time, I just want to rewind what happened right there. And then I'll fast forward it and catch.
Yes, thank you.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And
This is
there
so
are
fucked
similar
up.
statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate Software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
I
Woo!
appreciate your brevity too.
Get him.
You're welcome.
Mr. Brennan.
My man. Yeah, this fucking guy.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay, thank you very much. I'll get a decision quickly to you now.
Get the fuck out!
So defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
John O'Keefe or any witness.
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise
There's your
require
advance
that
notice.
evidence, if they think it
Right.
is an exception under the rule, then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Oh,
not
shit.
believe we will be opening on that at all.
All right.
Oh shit.
So, okay.
I wonder who's
So
going to
what
do
I'll
it.
do is not during the opening and only with advance notice.
Not during
And
the
rule.
opening?
What would the
Fuck.
advance notice be, Your Honor?
A week before a week before the evidence starts.
What can't he say during the opening?
He can't bring out any evidence of bad character of any of like the third party
That's
culprits
Paper 587, Mr. Clark.
without
Huh.
without 1 week's notice behind, and not in the
Proposed
opening.
Motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson.
Let's
It
hear this
also-
shit.
It also includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product, so any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
Okay.
Thanks.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration. Okay. So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March
I'll say.
10th, right?
I'll
With
say it is,
Michael
Bev.
Proctor being fired. Do you need some time to
Please boo
reconfigure
him,
this,
Will.
or you want
Please
to just
boo
be
him.
heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to
Well,
provide them?
they have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their
Yes.
positions, maybe they found him
Yeah.
unbecoming of an officer. I don't know, but those type of
I do.
positions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
What?
Is that a same timetable you would have whoever's arguing it for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
What?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, sure.
Okay.
Does the superintendent have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quick as I can. I have a lot of
Okay.
publications over the next week. I'll try to facilitate it. I just don't know.
Let me translate that. They're giving
Without knowing how
Brennan
much
a
is
lot
in
of time and
dispute,
her
Ms.
none.
Little, you have no idea how long it will
Right.
take you to address that, right? So, um, all right, so Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need.
Just for your audience, this is what I'm talking about. Proctor's firing. So the law is on Karen's side on
All right,
this.
So, Mr. Brennan, since we are making good time, I'll let
The
you go
law's
back
on
and
Karen's side on
finish
everything.
What you were saying when I gave you a 2-minute.
True.
I mean,
I cut you off after 2 minutes on third-party culprit, and then Ms. Giannetti, I'll give you both up to 5 minutes on this.
Oh, Jesus.
5 minutes is a long time, Ms. Giannetti.
It is
Let's
not.
see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're-
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where.
yeah, he's
that's
like,
where
if
I'm
you've
at
already
with
got
this
your
one,
mind
and
made up, why
I'll
the
hear
fuck bother?
different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that.
Wow. Yeah, like you're not going to give me the
Requirements
time
of
I need to
providing
argue.
evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice
at
or
Bill.
confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as
No, there doesn't. No, there doesn't.
the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness, there is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we have never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce?
Karen
There has to
didn't
be
hit him.
parameters and
That's the
limitations
evidence.
if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Sarabia fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce. Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character randomly is improper. It's unfair.
That's not
And
what
then
they're
it
doing.
causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is, and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we
Wrong.
think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody.
Wrong.
And that's not the way the court and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence.
What a
They shouldn't have-
shithead.
They can certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters.
Nope.
And it
You
would
got
be chaos.
conflicting statements with testimony
Right.
up
So,
the yin
Mr.
yang.
Nettie, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words.
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still go ahead. You can go over there. It's a little bit different
Yeah,
if it's
Nettie,
third
the
party as it
cerebral
goes to Bowden,
ninja.
but
See
we
what he's
know that
doing?
It's not
He's like, listen, if you're not even going to let me
admissible
talk,
know
fuck you.
about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can
Well,
you
it's
make
No, he
an
still our
told you he
position
doesn't
that
have to
we
tell
don't
you.
have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
Three, yes.
Okay, so can you tell me the three that
Brian
you say it
Higgins,
is?
Sure.
Colin Albert.
So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert.
Boom.
I have, evidence with regard to
I
each.
fucking
I'm
love
sensitive
this
to the
shit.
fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over there?
They're going on sidebar. I'm happy to give commentary, Will.
Go ahead.
All right, you got to turn the fan off while I'm talking to you, because I will literally get dizzy.
The sound is off. Oh, you gotta. Okay.
Are you able to still watch that? Okay.
Yeah, I can still see it.
By the way, I just want to apologize. I literally just ate very quickly in front of your audience, which could not have looked very attractive. So first off, Yannetti's right. He does not have to lay out his blueprint. He doesn't have to lay it out not only for the judge, he did not even have to tell them the three names of Higgins, Brian Albert, or Colin Albert, but we all kind of knew that's where they were trending. I would say with the supporting role from Chloe, the late Chloe Albert, but anyway,
Right.
he didn't have to do that. I'm okay that he did it. That's my opinion, but he did it. What's unusual now is the judge is literally hearing like a micro argument on substantive bases to support those positions that the defense wants to take against Brian Albert, Brian Higgins.
It's
At
a real
sidebar.
easy, yeah, but it's a real easy picture to paint.
It
have
is.
Brian, you have Colin Albert, who has had beef with John O'Keefe all this time. He lied about being in the house. We know he was in the house. Then you have Brian Higgins, who clearly had motive, on top of the fact that he's on video acting aggressively towards John O'Keefe just before that. And then sends John O'Keefe a text message saying, "You coming?" Right? Then you've got Brian Albert, whose house it belonged to, and on top of everything else, while they're first responders in his yard, he completely and totally acts like it didn't happen. Not to mention the phone calls that were taking place between Brian Higgins and Brian Albert at 2 a.m.
Got you.
It's an easy picture to paint.
He shouldn't have had to give her that. And thank you, JFK. You're right. He should not have had to give that level of explanation to the judge at this time or at sidebar. So
I agree. It was like what Betterow was explaining. He was like, all they have to do is prove, listen, Karen Reed didn't hit him with her car. The only other logical place to look is in the house, which is what most of us have been saying since the beginning. That's what I've been saying. The only other logical place is in the house. So
I agree.
That's all they have to prove as far as third party culprit.
Was McLaughlin just rubbing Hank's back right there? Looked like it.
Let's see, because we got time.
Yeah. I mean, there's definite physical contact. If he did that to her, she would have filed a law against discrimination complaint. Stat.
She was just resting her hand there.
Mm-hmm. Mm-hmm. But anyway, while we can look at a stack of what appears to be law books or whatever that is, maybe those are the missing data logs that we need
It's
in
like
this case.
printer paper and envelopes and shit.
This speed dating round of motions in limine crushed me. I didn't even take best notes. So
Dude.
Screw you, Bev. But the issue of what we were talking about, you can keep it on, Will. I'm okay. But the issue of Proctor's termination and misconduct, which we talked about during the lunch break, there it was. They just kind of argued that. I think I've bored my dog. She's like, peace out. Anyway, she's like,
Glover just walked out too.
Because they already know. This shit comes in. But the law does on this particular motion for Proctor's, the evidence of Proctor's misconduct and termination, which is the motion before the one that they're currently arguing on third party culprit. It does heavily favor Karen. I know you mentioned all of the evidence and these motions favor her. I do understand that, but it is pivotal as far as I'm concerned for the defense to be able to get Proctor's misconduct and ultimate termination into evidence. He was the lead investigator. And not only that, on the point of lead investigator, because we've seen through Buchanan's testimony before they really truly started to distance themselves from Proctor. But during 1.0, there was a conscious move to distance themselves from Proctor to make an implication that it was a team effort. We work as a team. It's more of a two-person interview structure. And
that's interesting. That's interesting because that's what they were doing during trial last time, but they sure as shit didn't list anybody as a team in Proctor's termination, did they?
Right. They actually called him, you have a police administrative body calling him the lead investigator.
Right.
So that report, and there's like two documents.
Crucial.
It is, and it's hearsay. So normally the report wouldn't come into evidence, but there are exceptions to hearsay. We want, as Team Karen Reed, we want that report to come into evidence. But even if it doesn't, we want to be able to confront Proctor with it, and frankly, maybe others. But it doesn't go unnoticed to me that Brennan, who's the staunch advocate for a fair trial and transparency, is suddenly trying to imply that this type of evidence concerning the lead investigator's misconduct and termination, it would prejudice the jury, and that shouldn't come into evidence because it might confuse them and look the other fucking way. So anyway, I'm a little punchy now, and now that my blood sugar went back up.
Scott says, if Hank says it shows Karen killed John because what had taken place prior, then Higgins and John at Waterfall has direct correlation.
Agreed.
Yeah, like if he's trying to say, right, that's a great point. So like if Brennan's argument is bad blood before Karen allegedly hit him, which would be at the waterfall, well, then all they have to do is show the bad blood that took place at the waterfall, and that's only between Higgins and Higgins, really, because John O'Keefe was smiling, like, whatever, dude,
Right.
So like Higgins was definitely the aggressor.
Higgins definitely was, and I don't believe, and I think someone did mention this to me when I asked the question last time. Like, I don't think that they even presented evidence of Higgins kind of doing, one of these at the waterfall into the trial 1.0. If
They
that was
didn't. They
right.
didn't. I gotta keep quiet about that.
Okay, you keep quiet.
I almost, yeah. But yeah,
You keep quiet. Anyway, while we're waiting, and I don't did we see counsel go back to their seats, or are they still at sidebar? This is highly unusual where the judge would make someone like Yannetti come to her sidebar to argue pretty sophisticated. Oh no, now they're back. Like pretty sophisticated substantive evidentiary positions on 3 potential third-party culprits. There's
Defense
other
has to
issues.
make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to
Fuck
address
yeah.
that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand
Like
up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving. We don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth is in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate.
Can you do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes.
All right.
Thank you, Your Honor.
Thank you. So 607, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. All right, the Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments.
Oh my
and
God.
Essentially summarize
Yeah,
arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses. And then the witness would have the opportunity to respond or explain or admit any type failures. this is
He's an
attempt to
expert.
bolster
Yeah.
a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
No, that's not what
That
he's
would be
going to do.
totally improper opinion and
Wrong.
inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime.
He
I've
should
done
tout
quite a bit of
reasonable doubt.
research. This is not a summary witness.
He's there
This
to
is,
argue how
not
the
a
investigation
witness
was conducted.
that has any relevance other than
Or
his
how it
own
should be
personal
conducted.
opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And
You
so
should
I
have
see
gotten
that
yourself a
this
police
witness is
expert,
really
Brennan.
simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds
Personal
for admissibility
opinions.
for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
Like, who's arguing?
God save
I need you to
Massachusetts.
start by telling me what you expect him to testify to.
Certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation
How
should
is
look
he
like.
an expert on that? How is that a field, and how is he an expert on it?
It's a
Is it
field,
something
Bev.
he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. I've
Um,
already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to, or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
witness
when
interviews?
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked them up, looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702, the federal rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education beyond that of an average layperson, in particular, in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report. One or the other.
That's what I need. That would be much more helpful to me.
Then I don't know what more the court would like from me.
So I wanted to know specifically what you intend to have him testify on. But if it's in his report,
it's in his. It broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him. We've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training.
There you go.
Best case practices for an investigative
so I guess
technique.
That's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see
Yep.
codification of it,
Yeah.
or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his
And
opinion.
maybe
or
the
to render
ATFs
an opinion and a
about
conclusion
destroying
concerning,
phones.
what he believes
Yeah.
are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it. Yes.
Mr. Brennan, did you want to respond?
Watch, he's gonna sit here, even though he was clear about
Mr.
it.
Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police.
Yeah, because he
This is
does it
just
right.
Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation.
That's
I
her
don't see any
constitutional right.
recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police
Cross-examine
Department
him.
again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with.
That's
I
a
don't know
lie.
that this witness has ever been qualified as a Bowdoin type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that
Too
the
late.
investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't
Bullshit.
think it's appropriate for expert witness testimony. This is argument by counsel.
Very briefly, I gently disagree with Mr. Brennan.
Gently?
He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense.
I
for
just
someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says,
You
well,
wouldn't
hang
be
on.
objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it.
Bullshit.
Do it. I'd love that. I'd love a shot at
Exactly.
I said, let's keep.
I'd love a shot
Take
at
personal-
cross-examining it.
That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowdoin defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, All
It's
right?
called
That
law. That's your
expert
case
testimony
site.
regarding a Bowdoin defense. I've never seen it.
Doesn't
Never seen it
matter
in
if you've ever
research or
seen it.
anything. So
I've
I'd
got
like
it.
a case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and
that's because of
searched
the good old boy
for
bullshit
a
there.
specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point, but there are plenty. There is a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field,
Massachusetts.
one that's utilized throughout the country
I need
all the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I
Unreal.
think that's it for the motions in limine. Did I miss anything? All right.
Yeah, see,
Oh,
she just didn't like.
Earlier, you alluded to this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll wait for, we'll put that off until the end. If I heard you correctly,
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
No, they've been arguing all fucking day.
We have not spoken.
Karen, if I may, on one point on the impanelment,
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate
Right.
questions. If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so
No
close
shit.
to jury impanelment.
Yeah,
It
how
makes
about
sense to me.
maybe make the jury instructions clear on the charges this time?
Yeah. And not
How
don't
about
have
that?
bullshit biased rulings.
Outside cases, no, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right.
I don't understand how she sleeps at night.
File your questionnaire, file
Me
your
neither.
proposed questions that you would like me to ask the Venari and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Obviously, it would be a day after Monday, then, right?
Yes, Mr. Unit, it would be after Monday.
We did file two motions today that at some point we'll need a hearing on.
Okay.
Two motions filed today.
This morning, so we're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better.
Well, one of
why
them.
don't we
Oh
go
no,
next
yeah, no, you're right.
Did anyone in the chat have any knowledge about two motions being filed today, even if they haven't been hit the docket? That would help me.
Dude, Kelly's on fire right now, man. I feel for her. Look, and it's just a show to this dumb bitch right here. Look at this photograph.
Oh my God.
Fucking psycho hose beast.
So
I held John's hand like 30 years ago, so I want justice.
and I still wear his badge number.
Lady sucks.
Man, okay. All right. Well,
What the fuck now? I guess it's just a sidebar right now. On
is it? Oh. I
Okay.
just so
Yeah,
your
they're not
audience
done
knows,
yet.
I did
she didn't adjourn court yet.
just so your audience knows, I dropped you a note to let you know I have until 4 if you need it, if they're
I don't
wrapping.
even know if I'm gonna stay on till 4. Shit.
No problem. But I know I had told them I had to drop off at like 3. So
Yeah, right on.
if they have any comments about, or I have a couple comments, if your audience needs to understand, but as far as that third party culprit defenses, the judge didn't decide on it. Yannetti, hold on.
So I will see counsel on whatever is outstanding next Tuesday, the 25th. And we'll do that at 11 o'clock. All right.
All right. So the 25th at 11
Okay,
a.m.
Thank you very much.
Thank you.
So what is that, Monday?
No, Tuesday.
Okay.
Are you marking your calendar?
No, I'll forget. Look at, dude, Yannetti's just fucking over it, bro.
He is over it.
I feel so bad for him.
Well, I feel mostly bad for him because he has to practice in the jurisdiction. So he actually has the most to lose if he flips his shit.
Right.
So.
Right. And he's close to it. Like the fact that he was just like, he was in literally fuck it mode. Like, okay, well, if you're not going to let me make my argument, then I don't have anything to say.
I agree.
That's crazy. I've never seen any of them get to that point.
So I think you can probably knock the fan off. You don't snipe Tom CPU's. You don't snipe Tom.
No, I do when he's out there. I do when he's out there sometimes, but I don't really feel the need to.
No problem. So I know it's been a long day for you. So I'll just recap, or we can answer questions. But whatever, your show.
Yeah, no, that's fine. That sounds great.
So that third party culprit defense, they set forth with 3 individuals: Brian Albert, Brian Higgins, Colin Albert. Didn't even have to do that, but they were identified. It looks like it's pending right now. The judge wants there to be the defendant to produce substantive evidence that they intend to rely upon to support the advancement of allegations and claims before this jury that there's a third party culprit defense as to those 3 individuals. It sounds like they've got the receipts, they've got the documents, but I don't love that they have to, spoon feed it to Bev and derivatively spoon feed it to Brennan. There's an element of trial strategy. You don't, you put people on notice.
What it is here. We're not going to hold, we're not going to hold Brennan accountable for the series of Brady violations leading up to this point. We're not going to hold him accountable for that. But we're also, on top of that, we're going to put the screws on the defense for giving up their strategy when Karen Reed has a constitutional right to keep her strategy close to the chest.
Yes.
And so she's being, the screws are being put to the defense here to give up the stuff that the Commonwealth won't give up, even though Karen Reed has the constitutional right to that.
Yeah. And if I were Will the Glarer, someone who gets fired up about shit like that, I would definitely focus on that in my life. The fact that she's got to blow her load and give them the whole keys to the kingdom outline for how she's going to try to prove this third party defense, that is in the epitome of depriving her of her right to a fair trial and to present a defense. It goes hand in hand with that decision in Massachusetts, which is one of, I think it's 2 states that requires you to hand over your impeachment evidence beforehand. It does violate her constitutional rights as far as I'm concerned. And I know I'm not alone with other lawyers on that. So that was an important motion. It's still pending. I'm not going to recap what we talked about before the lunch, but it does look like Yanetti's not opening. Interesting. I think it's going to be AJ. The defense is
I think
not.
so too.
I'm sorry, Will. The defense is not allowed to present anything, as far as I understand it, concerning the third party culprit defense in its opening. I'm curious to see how they do, but they don't need to. But she's not letting it in for opening.
That's weird. Like, why can't they go and say, this is what we intend on proving to you? This is what we intend on letting the jury see. Why can't they do that? If that's their defense, why can't they add that in their opening?
I agree. They should be able to. If I were to hearken back to Yanetti's opening, which I do listen to often, and my kids enjoy it. I'm trying in my mind to imagine.
I'm sorry, isn't the opening the foundation of foundations?
Yeah,
Delay?
it's when you set forth what the evidence is going to show. You don't make arguments. You
just say,
forth-
this is what you, the jury, this is what we intend on showing you, and what you should come to the conclusion when you see this.
Right. And even if going through Yanetti's opening previously, which the new opening was going to be different anyway, but even if we were to remove anything about third party culprit, there is a way to, I mean, I'm already thinking about it almost as, I'm wondering what Plevin's thinking about right now. Maybe he's working on his own opening. By the way, Plevin, if you're hate watching, I challenge you to a mock opening argument duel. You go against me. We'll give opening arguments. But anyway, there's a way to present a modified opening statement that doesn't mention the third party culprit defense, that focuses heavily on police misconduct, police malfeasance by it. Oh, God. What did I ask for here? Fucking love you, Will.
He's lying right now.
It wasn't like it wasn't, what was the word that she had? I forget. Anyways, if there was ever a time when they were going to be told what to do, and job one was going to be planting evidence, so that would be the time when they left the McCabe house, I don't know, say around noon, that they would go and get Karen's vehicle, right? Because job one is tampering with that vehicle, or at least seeing what conditions it's in case you want to tamper with it in order to plant that evidence. But they didn't do that. So to me, that's proof that Michael Proctor and Uri Buchanan were not planting evidence. They went instead. But one of the things I had always asked was, is that sloppy? Should they?
Shut up! Oh my God, I don't care!
All right, sorry, go ahead.
I asked for it. I'd be curious to see how many people are watching him right now. But anyway, so, they're not allowed to mention the third party culprits. They can mention Brian Albert and it was his home, but they can't go in that direction of actually pointing the fingers. But they're just going to talk about coincidences.
So wait a second, just so we're clear. So they can actually say that there is a third party culprit defense, that they just can't name the third party culprits in the opening. But in the opening, they could say there is a third party culprit defense. I'm confused.
No. Okay. So first, just to be clear, the judge hasn't made a ruling yet. So the answer is we don't specifically know yet what they can, if they can even advance a third party culprit defense. That's pending. But she issued a preliminary ruling that if she allows it in, as to Brian Albert, Brian Higgins, and Colin Albert, they cannot mention it in their opening.
Okay.
Which is, I don't understand. I don't understand her mindset, so it's kind of hard to explain in a logical decision to you in a logical fashion. But she hasn't made a decision yet. We do not know if she's going to.
Right. No, I get that the decision hasn't made yet. I'm just trying to think hypothetically once a decision is made, but
how they do it.
Well, right. Well, I was just right. Well, if they're planning on presenting a third party culprit defense, like, it doesn't make sense to me that they can't tell the jury we plan on proving not only that Karen Reed did this, but somebody else had to have done it. And we're going to narrow it down to 3 people.
So while I don't understand the judge's mindset, what I think the defense could do if they're allowed to ultimately advance a third-party culprit defense against those 3 individuals, if Bev won't let them open with it, they're going to present an opening argument that talks about that maybe they'll be able to say she was framed and the evidence is going to show that. Maybe she'll let them get that far, but they'll focus on the evidence will show that there are way too many coincidences. You're going to hear about butt dials and deleted Google searches and inverted videos and, evidence
You're
that
going to hear about a conflict of interest and inappropriate, a conflict of interest between the lead investigator and the owners of the home. And you're going to hear about statements that weren't taken, that you're going to hear about evidence that was not logged properly, if logged at all. You're going to hear about, they could just go on and on. I could write their opening statement.
I was just going to say, you should consider doing that. But yes, that's a strong opening argument type of theme. So I don't want anyone to panic. If they can't, if Bev allows third-party culprit, which she should, and they're not allowed to mention those 3 individuals as the potential suspects in opening or as the potential suspects in the opening argument, there are ways of arguing around it or dancing around it. So do not worry. What you should worry more about is if she denies the opportunity to Karen to present a defense. It's a fair trial. It's rebuttal. She's allowed to rebut these specious and allegations that have been raised against her by the Commonwealth. So that's everyone sit on the edge of their seat about that. Oh wait, hold on. I gotta yell at my Alexa to not chime because my kid's bus is gonna come home soon. Hold on 1 second.
Okay.
Okay. So there were motions argued for Garrett Wing, the dog bite expert who was on Melanie Little's show. The motion to bar him. The judge basically said she wants the defense to produce to the other side, the Commonwealth, all of the rules.
And the questions that they plan on asking him, and that's crazy.
It is. It absolutely is. It's illogical. There's the motion. So that's pending. She wants the defense to hand over all the reciprocal discovery on Garrett Wing. Then there's the police expert, the investigation expert in support of Karen's Bowden defense. A Bowden defense is where a defendant argues that the investigation was so shoddy that there was so much misconduct, so much ineptitude that it could not properly be considered to be a sufficient investigation. It's where the defendant has a right to take jabs at the quality of the investigation, ranging from Stop and Shop bags to Solo cups to, evidence sitting in the back of a car and laying out for days at a time on butcher paper, you name it. She's allowed to present that. The problem becomes in Massachusetts, there does not appear, although I haven't done the legal research, nor will I rely upon other streamers to do that, like people like Brother Counsel, for example. He loves doing research. But, there appears to be no published case in Massachusetts which would permit a police investigative expert, and by police, I'm using it in quotes because this guy's a retired FBI, to present evidence in the form of an expert opinion to support a Bowden defense. So there are, other jurisdictions, it's extremely common. Thousands.
Right. That can't be. I find that extremely odd.
So do I.
That Massachusetts you cannot find where a former law enforcement agent testified in a trial as to the expertise and practices as to, from his expertise as to the practices of law enforcement and the standards of law enforcement that should be held up. I find that shocking that that's never happened in Massachusetts. What?
I do too. And it's very common elsewhere. But more importantly, the judge said, Mr. Jackson, are you aware of any cases in this jurisdiction? And he has an ethical obligation to be honest with her. So he said, no, I don't know of any in this jurisdiction. But he's going to check again. And that should not be
find
the issue.
something. Yeah.
But that should not be the issue.
It shouldn't even be an issue at all.
The way it works in law is that if you don't have binding precedent, meaning cases in your jurisdiction that support your position, you are then to go to what's called persuasive authority. And you go to other jurisdictions, other states, and other states are replete with cases where investigative experts come in to support Bowdoin defenses. I've presented Bowdoin defenses on police matters early in my career when I used to do police defense work. So with all of that said, the judge makes her snarky little comment like, well, if you want your motion granted, rely upon binding precedent first.
She got pissed because Alan Jackson was like, well, my reason is it's the law. It's called presenting a defense.
Right. And if the judge denies, or if the judge, wait, whose motion was it? It's the Commonwealth's. If the judge grants the Commonwealth's motion to bar Easter, that is absolutely ridiculous. It violates Karen's constitutional rights. And even though there's no binding case that apparently on an investigative expert coming in and giving what Hank called subjective opinions, all experts give subjective opinions. It's their opinions. That's why we go through
That's
Dahlberg.
why they're called fucking opinions.
Correct. So if there is a scenario where the judge grants the Commonwealth's motion and Karen is deprived of the opportunity to present a Bowdoin defense in Massachusetts, that is a huge appellate issue. I'm calling it now, as well as the others I've pointed out as Easter eggs along the way, including the denial of, for example, Bettero's pro hoc vice admission, etc., if she were to ever get convicted. But right now, we're in a position where it's just more and more evidence of the prosecution, the Commonwealth, just trying to kneecap her. I need to find a better synonym than kneecap. But they're just trying to deprive her.
I say basically the same thing. I say chop her legs out from under her.
Yeah,
That's all it is.
And then the last point
that's shady in and of itself.
Yeah.
When the burden of proof is on you, then why are you so focused on the defense, and why are you not focused on just presenting your case and proving to a jury that she's guilty?
I loved AJ's moment, which was, do it.
Right. Please.
And of course you've got
because he's saying I killed two birds with one stone. Like, not only am I going to have this guy come in and give you federal standards, state standards, this guy studied Massachusetts state police standards.
Right.
He went over all of that. So please get me a Massachusetts state trooper expert to actually try to rebuttal my witness, to try to rebuttal my fucking expert, please.
And that's, you're absolutely right. And the issue with this, Will, is that is what, 2 points, and then I promise I'll stop. That is why, that's what cross-examination is for. It's going to be, if it's allowed, Easter's opinions, the police expert, which I think is going to be really, really good. I haven't seen the report, but the prosecution has. So it's going to be Easter's opinions. That Brennan has notice of it. He's got the report. Easter is qualified. Brennan can prep his witnesses now. Brennan kept saying, like,
he's not even arguing whether or not the guy's qualified. He's not even arguing that.
Correct. So Brennan is arguing, and we call it an argumento ad absurdum. He's arguing, well, once Easter gives his opinions, I'm going to have to call my fact witnesses back and they can defend their conduct. No, that's not the way it works.
He's talking about, oh, well, it's going to be a waste of time. Like that's his whole point behind it is like, we're going to have to do all this and we're going to have to do all that if they do that. Like, and so that my client has that right to put you and make you jump through those fucking hoops, dude. Welcome to the law.
And it
Welcome
is
to trial.
And Brennan, if you're listening, this whole fucking thing is a waste of time.
Yeah.
Okay? But the way it works in law is you get notice of an expert from the other side, you get his CV or resume, you get his report, which you have, and you prep your damn fact witnesses, including all of your law enforcement officers and, as I maintain it, conspirators. You prep them around those opinions so they can now give their testimony, which is supposed to be truthful under state perjury laws, and they will give their testimony one time. And guess what? Then the defense comes. And when Easter gets on that stand, he is going to shred the shoddy and improper dilatory police investigation conducted by the Massachusetts State Police and the Campton PD, which was conflicted out, and he is going to hammer home all of the misconduct of Trooper Proctor. And Brennan, you're going to be lucky if you're left with your glasses when he's done with you. So this is the way it's supposed to work. It is a fair trial. There is no gamesmanship on this side. And I am angry, if you can't tell, that it got this far. And it is a complete waste of time. So I'm going to get off my soapbox.
Totally crazy.
But it's been great hanging out with you.
Yes, it's been great hanging out with you too. It's always great hanging out with you. Thank you, Nan, so much.
Thank you.
It really means the world to me that you took the time out of your busy day to hang out with all of us.
Oh, no problem. I've been multitasking. If I missed anyone's questions, please let me know, and maybe I'll see you again soon.
All right, right on. Thank you, Nan.
Thank
we'll see you soon,
guys. Bye.
Bye. All right, my friends. That's going to be it for me. Thank you guys so much for hanging out. I'm sure Aiden's going to end up on Howie Carr at some point today. I'm not going to stay live long enough for that. I'm sure it's going to be like somewhere around like 4:05 or something like that. But keep an eye out for that. Guys, you guys are absolutely fantastic. Please make sure to hit the like. Make sure to subscribe if you're not subscribed already. Make sure to double check. And make sure you're still subscribed because YouTube, for some reason, unsubscribes people randomly. It's very weird. But also, thank you guys so much for all of the super chats and the support. It means the world to me. Please, if you're feeling generous, support Karen Reed. Her defense fund link is pinned to the top of the chat. For anybody who already did donate, thank you guys so much for that. And also, I want to thank my mods for hanging out as long as they did. You guys, everybody with a wrench that did anything helpful, and even the creators who have wrenches who added insight. Thank you guys so much for hanging out and doing that. And I owe you guys one of these.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. 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 I think we got a super dad.
How dare you?
Danielle Franz, thank you so much. Did anything you hear today make you worried about the outcome of the trial? Hi, Nan, Morris County News. Love you, Nan and Will. Sorry, Nan's not here to answer that question. I know this is definitely more up her alley. Everything that I heard, let me word it like this. I would honestly say the way that I would answer that, my uneducated opinion, I did not hear anything that makes me worry just yet, other than the usual bullshit that we're seeing, the bias. That concerns me, but that's always concerned me. But anything today specifically that made me worry about the outcome of the trial any more than usual? No, not yet. I'm not there yet. But anyways, guys, you guys are absolutely amazing. Thank you guys so much. I love you guys very much, and we will do this again very soon, my friends.